Lordship, I have received, I have collected 3 judgment copy, Lordship. May I give the reference?
No, any Supreme Court decision?
Supreme Court, Lordship.
Party name, please name the parties.
Tell party names, Lordship. I'm giving a copy, Lordship.
Party name cannot be what? Party names means who versus who.
Lighted.
Yes.
Just reading out. Peri Kansara. Perry. Peri. Kansara. Sagra. Kncgra.
No, don't spell it. Peri Kansara
versus Smriti. Madan Kansagra.
Smriti Madan Kansara.
Lordship.
Year of the
So those parties,
Lordship.
they are maternal uncle and
maternal mother.
Mother and who is Peri, who is Smriti,
in that judgment, Lordship.
Yes.
That I don't think is a declared, Lordship.
So that you have to study.
Lordship.
You check it in Peri Kansara, they are for husband and wife.
Lordship. And the other 2 are there.
No, kindly appreciate this.
Lordship.
So while you have read the decision, you did not mark that it is a decision between husband and wife.
Lordship.
That means mother and father.
Again.
Please appreciate that.
Lordship.
Then what is the other decision?
Other decision will be Ashish Ranjan.
Yes.
Versus Anupama Tandon.
So Ashish and Anupama, they're again father and mother.
Father and mother.
Don't fit to our case.
So don't fit to your case.
So why should we go to those decisions?
But
you are unable to find
face
out
color.
a case fitting.
Both Peri and mother, they have referred to certain cases.
Proper reading.
And
Sorry to say.
Other one, let's say Gaurav Nagpal versus
No.
Someda
Gaurav?
Nagpal. Gaurav Nagpal.
Gaurav Nagpal versus Sumedha
Sumedha
Nagpal.
Nagpal.
Gaurav
Yes,
Sumedha again father and mother.
Those 3.
But Peri
please
has
we
referred to
request-
earlier decision.
We request all bar members,
I will
please bring fitting decision. There are fitting decisions,
Let's-
100% fitting decisions.
I will come. I will
Not
come.
that you will be just throwing some
No,
decisions for our perusal.
I say that because I
Both of you have understood. Both of you have understood
Lordship.
who are the parties in a child custody issue.
Lordship.
And both of you are conscious. Welfare of the child should be
Lordship.
paramount consideration.
Lordship.
So bring a decision. And the uncle in maternal side. Grandparent and uncle in maternal side. For better interest, for proper justice, this court feels it appropriate to have an interaction with the minor girl child. As assured by the counsel for the petitioner, Sri Mahapatra, the counsel for the petitioner, they are ready to the petitioner side, na? You are petitioner side.
I'm from applicant.
No, yes,
applicant.
petitioner side, okay. They're
Applicant.
ready and willing to bring the child and produce before the court at 10:30 on 14/7. This court also direct presence of the personal appearance of the presence, like the presence of the maternal uncle, and so also the father and the subsequent wedded wife on the date fixed for the purpose. Place this matter on 14th. Produce all the parties.
Let's see. Okay, grateful.
Please convince them it is only interaction. Because at times for children and for parties it is traumatic. They court don't upon Mr. Jujar Singh, that is your
Case
also.
is deferred to 14/7 only for interaction purpose. It may be open to both the counsels to produce written note of submission along with citations if any to support their case. And please confine to the case at hand.
Right.
Parametric case. So otherwise don't please throw decision.
Again.
What a case re, muto learned brother kohile. I was hardly 7 years lawyer then. I could get 30 judgment by that point of time.
Aye.
Supporting my case.
Right. And this issue was also same.
Both age learning so. And I was fighting with the great senior counsel of this court, Mr. S.K. Padhi. So, and Justice R.C. Patnaik. So therefore, And in another case, what happened? In two cases, I found both of them have become senior counsels in the meantime. I don't name their, I don't utter their name. Both have become senior counsels. In one case, there was a matter for grant of injunction. Okay, appeal over. Then in writ petition.
Yes.
Oh, Khali, say, in one particular decision.
Acha, single.
And after taking into account all those 25 decisions, the court has given its view.
Right.
So instead of placing the
And all 25 judgments,
main decision, which has already attended to all these decisions,
that will suffice.
because she found all the decisions are referred there, she wasted our 1 hour time in placing those decisions. Finally brought that decision.
Oh, good.
Then I said her, what is this? You could have brought this decision only, we could have saved our time. So therefore, that time has gone. Now artificial intelligence has come.
Keyword search challenge.
You must be
Let's
balancing yourself. No,
The certified copy was not there, my learned friend.
Pardon?
already. The certified copy was not available on the last
it is
occasion.
filed.
It has been filed.
Okay. It was adjourned for that purpose.
Yes.
Okay, now you challenge Annexure 10 an award.
Annexure 10 an award where the issue is, while granting the relief,
It is challenged by management.
management is by the principal employer.
You are the principal employer.
Principal employer
Also added as management.
as management.
So
One of the first party management.
it's reference. What was the reference?
Yes, if your lordship should just
Come to page 84.
annexure 6, your lordships may see.
84, page 84, straight to account.
Page 84.
All right. Well, that is in the part of the award, but the
They
original
have
order of
quoted reference.
original order of reference, whether refusal of employment of Sri Nabakishore Jena and 4 others by the management of Katsroy Infrastructure India Private Limited, presently known as Messrs. KSS Petron Private Limited. So and so under
Then
the
come to
principal
the
employer.
direction. So therefore, there is clear case whether ouster of the workman by his immediate
contractor,
employer,
by the
by his immediate employer, working under the principal
Principal.
employer, remain justified or not. So be clear.
yes, ma'am.
Now come to the direction.
Yes, your
Who has
lordship.
been directed?
My lord, 96.
Yes. Now come to page 96.
96, my lord, the last 6 lines.
No,
are
read
this.
the entire.
The reference is answered on contest against management number 2, that is me, the principal employer, and ex parte against management number 1.
Contest against management number 2. You contested.
I
that.
contested.
The immediate employer did not contest. Now, refusal of
The refusal
employment.
of employment of workman so and so, presently known as so and so is held
I
illegal
so and so,
and
presently known as so and so,
under the principal
one
employer
is
message
held illegal.
is held illegal.
So therefore, the direct burdening on the
Employer,
immediate employer.
immediate employer.
Immediate employer.
Immediate employer.
Now,
the management number 1, Messrs. Cases.
again, immediate employer is directed to
to
pay.
pay. Failing
Then-
that, my lord, in the last 3 lines, if your
Yes.
lordship should see, failing which,
Yes.
the principal employer, management number 2, shall make such payment with 10% interest.
Now have a pause. You have no role except performing the non-performance of the immediate employer.
Immediate.
You can't challenge such award.
No, my lord, I've just,
Please never start your argument with no.
no, I'm not saying, my lord.
No, you started your argument saying no. Never start, Mr. Nanda. It's a etiquette. Because what we understand, and as you read now, it's a clear direction to the immediate employer. So it is immediate employer getting affected by such award. Your role is limited to the extent if the immediate employer doesn't work out, doesn't challenge, then you have to perform your duty. So deduct it from his contract bill and
No,
pay.
but the only problem is the contract is completed long way back. he is no more the continuing
You go
contractor.
for recovery,
No,
go for recovery.
no, yet no dues are to be paid to him.
No dues. It is only the compensation.
Chief.
That is why, my lord, there is
Even then,
that is why.
it's a decree.
Contractors,
No, nothing is left. There was an arbitration proceeding
Even
that has
has to be.
also been resolved, everything.
so it is open for you to recover it.
Recover.
But I can't recover on
So that
No, no,
clarification you want.
You can't say. You can't say it has
that
to.
is already there. So that clarification.
Sorry, Mr. Nanda will not
So
admit.
just grant me 1 minute time,
Yes.
subject, just to show one decision,
Yes.
what I am supposed to pay to the workers is not the compensation amount, irrespective of whether the employer pays or not.
No,
That
you are binding. You are binding. See, you must not have gone through the contract with your contractor. Any liability comes out of it will be a liability of the contractor. And you have a role as a principal employer. Therefore, please don't pursue.
I'll just, subject to your lordship, I'll just place one section, then
For
one
what?
judgment.
Or what?
What is my role so far as the payment of dues of the employees are
No,
concerned?
it is
under
an
the
outcome of an award. It is outcome of an award.
No, award, I understand.
Unless the Mr. Nanda, you have to understand that this is a litigation between the worker and the immediate
Employer.
employer. As a fallout, there may be some direction necessary. That's why the principal employers are made party. It's only a abundant caution, by way of abundant caution, somebody is made party because workmen should not suffer.
But
So
then, my
please-
lord, vis-a-vis that also my responsibility, the legal responsibility.
No, not necessary. Now your legal responsibility is straight to a proceeding for execution against the employer.
If your lordship.
He is not challenging, Mr. Nanda. You have to understand. He is not challenging an award against him.
If your lordship may.
He remained expert. He is so adamant. He knows. He knows a time will come. His term will be expiring. He will not be there. He can't pay. If he is forced to pay, then a litigation will come. He is very cautious.
Your lordship may just come to page 45 annexure 2, where the execution
Page-
proceeding has been initiated against me also.
Pardon?
Page 45 annexure 2.
Yes. What has been initiated?
The execution proceeding.
Obviously,
So
you are
If-
shirking from your responsibility.
legally, that is under the, my lord, Minimum Wages Act, the
Maybe.
execution.
Maybe.
Now again,
That's a different cause of action.
separate
Not
cause of-
assailed here.
But so far as the dues
Mr.
of
Nanda,
the,
sorry, with my acumen, I hope you have no case. And my brother will
I
agree.
bow down to your lordship's views.
Please,
If your lordship should just grant me,
please, let us not waste time further. You know the law very well.
that is why, my lord, the
You try- you are
judgment is
trying your
direct.
best.
The judgment is direct on the
Yes,
issue that beyond the wages.
You can go very well. At the submission of Sri Nanda Learned Counsel for this.
And the company is better equipped also than
No,
the
I'm not, that I cannot object to or otherwise,
No,
but the law.
The whole philosophy of the award is that it should be enforceable by the workman. And the company, the immediate
Principal-
employer is much well equipped.
No, the principal employer.
What I was yesterday at Sambalpur.
Be a benevolent employer, principal employer. Your workman is suffering. Your contractor is playing with him. How long the worker will be allowed to suffer?
No, this is only,
He is
instead of
rotting.
reinstatement, only
Tell
compensation
when
amount.
will pay?
It is
Tell when
compensation.
will
it is-
pay?
That I cannot, but.
There is already loading of 10% interest. You
I
have to remember
understand
that.
that. I understand that. So the date I cannot,
So
from my,
you
your
don't
lordships may pass the order.
All
they
right,
will
we
walk
pass
out.
order. We pass order. At the submission of Sri Nanda.
Only I suggest if your lordships may take into account one judgment which says that I am not responsible to pay anything beyond their wages, which has remained unpaid, the arrears of wages which
Mr.
remains
Nanda,
unpaid.
provided such an adjudication is available.
No, here what they have saddled me, the liability
have you-
is in default.
All right, assuming such a stand is available, please come to your written statement. Where have you stated that?
I'll just take a look.
Please come to your written statement. It has copy of written statement file. 66 annexure 8 टा तांकर तो
Your lordship may come to annexure
Up
8.
to page 66. So
66.
that sentence.
No, it is on compensation because
Oh, sorry. Then this is non-dispute. This
Yeah,
is non.
then
Mr.
it is beyond.
Mr. Nanda, you should have been more careful at that stage.
I can't.
If a liability comes, then my liability is to this extent.
No, liability is, I cannot fathom a court saying that if he doesn't pay the compensation because
Sorry.
there is no
That cannot
dues.
be adjudicated here.
That those are
Sorry, that cannot
dues.
be adjudicated here. Yes, we can't. It's an industrial dispute award. We can't go beyond this. Term of reference is something. You are raising something else.
No, I'm not. I'm.
You have not taken stand. You have not asked for the court to frame a issue to that effect.
Compensation cannot be an issue whether in
Okay,
lieu
okay.
of.
All right.
If your lordship
All right,
could
all right.
see if the termination is bad.
All right.
The
Who assists
consequential
you?
is
Who assists you?
Mr. Sahu.
Mr.
Lady
Sahu.
Prasad sir.
At the submission of Sri Nanda, DP Nanda, senior counsel, assisted by Sri DP Sahu. Matter is taken up for fresh admission. The Nanda taking this court to the reference involved read together with the award passed in the industrial adjudication at annexure 10 by the ID case 5 of 19. Our date date was 23rd March 2022. Taking to the plea available herein in the writ petition, contest the award on the sole pretext that while admitting that the petitioner presently is the principal employer involving the workman and the immediate employer already involved in the industrial adjudication.
Your lordship mentioned immediate employer being the
Taking to the
contractor.
plea, please.
I'm sorry.
Taking to the plea in the writ application, Mr. Nanda advanced his submitting. In the meantime, contract with the immediate employer being over, the contract got vanished. There is no amount lying with the principal employer to facilitate recovery of the awarded amount. A judgment over awarded amount from the immediate employer. There is also no scope available to the principal employer to recover such amount in the event the principal employer discharges his role by way of payment to the workmen involved herein. Further submission of Sri Nanda appears to be the ultimate award directing payment of compensation to each of the workmen, and the amount directed therein should not exceed the wages to such workmen
Wages and arrears of wages.
in the course of employment. It is on the above premises, Sri Nanda attempted to challenge the award involved herein and request this court for interfering in the award so far it relates to principal employer, the present petitioner is concerned. State Council in defense of the award involved here in submits, who is there, Mr. Panda or Mr. Misra, Mr. Sonok Misra? In his defense, defending to the award involved here in submits, person, both sides, take your seat. Take your seat. Because I am to touch all these points. I am very conscious. Yes. Submits. The petitioner has the simple role of principal employer, being the second party management, incorporated in the industrial adjudication involved herein. Being the principal employer, the petitioner has a limited role to discharge the liability on account of immediate employer. In the event immediate employer fails to discharge his responsibility as an outcome in the industrial adjudication involved herein. Further submission of Sri Misra appears to be, once an award is already involved, directing discharge of responsibility by the immediate employer on the holding that there has been illegal termination of the workmen involved, and unless the immediate employer accepts such order or award, the award becomes final, unassailable even by principal employer. The only course open here appears to be on payment, on discharge of his responsibility by the principal employer. There is sufficient provision under the Industrial Dispute Act for working out the payment discharge by the principal employer as a burden on the immediate employer. It is in the premises, Sri Sonok Misra Learned Counsel for the state supported the award involved herein and object entertaining the writ application in the admission stage itself. Considering the rival contentions of the parties, this court records submission of senior counsel that the present petitioner herein, appearing as second party management in the industrial adjudication, undoubtedly the principal employer. Getting into the reference, this court find government in its appropriate authority at the following reference. अच्छी reference टा annexure केते हिची?
Annexure 6.
Huh?
Annexure 6.
Page?
Page, I'll just, page is 64.
Yeah, 64 अच्छी scheduled portion. Only scheduled portion, okay. By its referral order dated 5/9/19. Management in its, the management in present, the principal employer, as management number 2 in its appearance, filed the written statement stating therein that, admitting therein, that the workmen involved wherein were all under the employment of the contractor, the immediate employer involved wherein, There is also admission to the effect they have all worked at the site of management number 2, Messrs. Jindal India Thermal Power Limited, Konya, the present petitioner. But however, being engaged by the immediate employer. The further plea of the management in the written statement appears to be the management petitioner herein, being the principal employer, was not liable to serve any notice prior to refusal of employment to the workmen by the contractor, the immediate employer. It is further contended, management 2, being the principal employer, has already paid the dues to the workmen pursuant to the orders of Learned S.D. Jain Talche in terms of provisions of the Payment of Wages Act. As the immediate employer did not turn up to pay such dues to the workmen. The last submission through the written statement appears to be, of the present petitioner appears to be, since the workmen were employed by the contractor, the immediate employer, are not entitled to reinstatement with full back wages under management 2. Keeping this in view and the statement of claim further, evidence laid before the industrial adjudicator, there has been framing of following issues. Issue page 88, Roman 1 and Roman 2. Reverting back to the subpara, reverting back to the submission of Sri Nanda, in his objection to the implementation of award as against management number 2 petitioner herein, on the premises that the management's responsibility, management principal employer's responsibility should not exceed to the labor component admittedly operating in the contract itself. This court find a written statement of the management petitioner herein absolutely silent on this. There is no pleading nor advancement of argument, no evidence to support all such contentions. Contentions being raised in a writ petition involving an industrial adjudication, propriety of an industrial adjudication. Writ court has no such jurisdiction to enter into, no jurisdiction to enter into cases outside the purview of the industrial adjudicator. This court therefore outrightly reject contention of Sri Nanda on behalf of the petitioner. Coming back to the other aspects, there is no denial that the petitioner herein is the principal employer and has a responsibility to discharge the non-discharges, lawful dues in favor of the workmen not being discharged by the immediate employer. Undisputedly, the immediate employer has run away even in the stage of industrial adjudication and was thus held ex parte. This court here also finds এটা কেপের ডিউস
Dues
Subhuni,
during the working period.
It is to Subhuni.
Dues during the working period, whatever they had filed in the execution case.
No,
under the-
where
Hey,
it said that
Tankara,
these workmen
এই to adjudication hela, this is for the same period.
This is for the same period only. because
Same
the
amount.
condition- No, amount is different. If your lordship should see here, it is, the issue reference was regarding termination. There it was the unpaid wages.
Therefore, the compensation will be related to the unpaid wages.
No, it has not been. Unpaid wages has all been paid.
Then in lieu of reinstatement, you
Reinstatement
get
that
something.
has been-
Therefore, this amount cannot be included there.
No, it cannot be
Ah, so-
included there.
Right. All right.
If that is a separate component
Okay,
altogether.
okay.
There is the area
fine.
component of the wages.
We
But
understood.
then you should have argued the res judicata before the industrial tribunal,
Hmm.
because the
Then
case.
adjudicata হবে।
No,
Company.
because the termination,
As
these are two
my lord says
different
that,
issues.
so the written statement was somehow misconceived.
No, the
I mean, no comments actually.
No,
I mean, I'm not commenting
It
on
is
that.
admitted fact. Mr.
different
Nanda, there
issues.
is nothing to be hidden.
No. These are two.
It's a defective written statement.
Maybe I cannot.
No, it is not maybe. We have to admit, we are with papers.
No, because
I have gone through the written statement, I am dictating.
I cannot comment on
No,
other
maybe
councils.
that's.
No, I cannot comment on other councils. preparation.
Actually, it should not be confused.
Yes.
Factually, it is at times the written statement should be.
Mr. Nanda,
absolutely sharp and
at
clear.
our age, it is protecting law rather than protecting the parties.
No, I'm saying the lawyer.
So therefore, maybe
I'm
jo
saying the
ଆପଣ
lawyer.
କହିଦେଲେ,
I'm saying the lawyer,
no,
not
maybe,
the law.
maybe ଟା ଆପଣ କହିଲେ ନା. So there you cast a aspersion doubt,
No.
cast a
I
doubt.
think I can't, I should not be
It
raising
is,
against a fellow professional.
please admit some wrongs have been already committed, cannot be corrected now. Your written statement is gone, spoiled.
I just asked my learned friend.
Yes,
also.
that's right. Therefore, be benevolent to have a justice. ଆପଣ ଯେମିତି employer, ସିଏ ବି ସେମିତି worker. So let the justice prevail. It is who is suffering, we don't bother for that. କୋଉଠି ଅଟକିଲା? In the industrial, and did not face his litigation in the industrial adjudication. So therefore, and thus declared expert. It is in this circumstance this court find the petitioner herein has a statutory obligation to take up the responsibility on account of the immediate employer as a fallout on the direction in the industrial adjudication. Furthermore, this court finds even at this stage also there is no challenge to such award by the immediate employer, leaving no scope for the principal employer to be abided by such award. Considering the statutory role of the principal employer involved herein, question as to it is recoverable or not recoverable. This court is not assigned with any opinion or advice to either of the parties. However, this court, however, makes it clear, Industrial Dispute Act makes sufficient provision to attend to such situation. Well, nothing prevent the party has its appropriate advice from counsel engaged by him to pursue his further remedies in the circumstance. Okay, it is in the circumstance, and for the limited role of the principal employer in an industrial adjudication, compelled to discharge the responsibility of the immediate employer, this court find the direction of the industrial adjudicator in ID case number so and so, hour dated so and so, is bound to be complied. The industrial adjudicator has already made it clear. Failure of the principal employer to repudiate the claim and the benefits in favor of the workers on account of failure by the first party management therein, the immediate employer, the amount will be charged with 10% interest per annum till realization. This court find the award was passed in 2022. There has been no discharge of the responsibility of the principal employer even after 1 year. However, considering the principal employer was pursuing his remedy in this court by way of this writ application, while dismissing the writ application, this court observed in the event the compensation awarded by the industrial adjudicator through award annexure 10 is not released with interest as awarded by the industrial adjudicator within a period of 1 month, the workman shall be entitled interest at the rate 15% after 1 month, after lapse of 1 month being granted by this court. Yes.
Lord, one line
Petitioner
subject to
sent
Lord,
this, however.
the order may be wrong in the sense to limited extent that statutory liability or lordship may say legal because statute doesn't.
Oh, that is to be adjudicated in appropriate proceeding. We should only say
No,
under the
since your lordship said
Contract
that
Labor Regulation
statutory,
Act, Contract
Section
Labor
21.
Regulation Act and Industrial Adjudication, you are very well termed as a principal employer. So everybody knows what is the role of the principal
No,
employer. And again, it goes down to the contract between two parties. ଆପଣ କଣ contract
no,
କରିଥିଲେ?
but I'm
Contract
saying that
କରିଥିଲେ,
statutory
ସିଏ ଦବ।
liability and legal liability.
And there are some hidden agreements also because statute is clarified. Why should there be repetition of the statutory provisions? It is only written in all contracts. All parties will be abided by statutory provisions. PA, VSI, these minimum wages, payment of wages. These are contractual obligations. So find out the other options.
No, but I was just stating that statutory, your lordship said statutory, I said legal liability because that will, because the compensation is not part of 21(4). So your lordship mentioned legal liability instead of statutory because that will make the order wrong.
Kahin statutory nuho kahingi?
No, my lord, compensation
Contract
cannot.
Labor Regulation Abolition Act.
Nahi. Seita pai.
ଏଥିରେ statutory responsibility ନାହିଁ ID Act ରେ. If you lose a case,
No, my lord, even under the ID Act, so far as contract labor is concerned, contract labor is concerned.
Sorry, you have a responsibility. Once it has a direction of the
All right, I just wanted to
statute
point
says
out.
by way of execution it can be recovered.
Obliged.
Or statutory and or legal liabilities କରିଦିଅ। ଠିକ ଅଛି। Yes.
Item number 3. May please allow.
Yes, Mr. Mahanti, what is this again? Award by workman here.
Exactly. My award
Please,
starts
please be on
from
mic.
page 62. Starts from page 62, ma'am.
ମାଇକ୍ରୋଫୋନ ଟା ଆପଣଙ୍କ ସାମ୍ନାକୁ ନେଇ ଆସନ୍ତୁ. You bring it towards your rather left. ଆପଣ ବେଶୀ ରାଇଟ୍ କୁ ପଳଉଛି. ଆପଣ ଲେଫ୍ଟ ଆଡକୁ ଆଣନ୍ତୁ ମାଇକ୍ରୋଫୋନ.
The award,
The dispute failed.
dispute accepted, and they have said that the very action is illegal. At the same time, I have been awarded with 50,000 rupees. Such a bigger
50,000
amount.
only to each second party within a period as compensation.
Exactly. No
But
reinstatement.
there is a finding, there is a successor in interest.
Successor in interest.
So a burden of the earlier employer has been shifted to the successor in interest.
They have
ଆଉ
admitted.
ସେଥିରେ କଣ ଆଉ ପୁରା ଟଙ୍କା ଆପଣଙ୍କୁ
Pura nahale bhi 50,000. So admittedly, when my termination was declared to be illegal and unjust, only 50,000 compensation. The four workmen are there. Such a meager amount has been awarded, and knowing very well that the other co-workers have been still working.
You are the only workman there.
And four workmen.
Four workmen.
We are all drivers.
What was your age?
My age is
ଆପଣଙ୍କର age ସେତେବେଳେ କଣ ଥିଲା? Dispute ହେଲା ବେଳେ?
dispute hela bale I was 38, 40, 49 because now I am 49, 45 and 51.
Now you are 50 plus.
Again, one person is below 50, two persons are below 50, others are 51 and 50.
Please come to your written statement
Again,
and
It is
show
available
us
at
that
page-
you are unemployed.
my
Or
it's at
your statement of claim.
page 14,
Your statement of claim.
page 14,
Page
14,
14.
14.
Yes. Please take us to that position. ଆଉ ଖୋଜିଲେ ହବନି.
I was not
You say you have
gainfully
been
employed.
awarded with a very meager amount.
Exactly.
So then you must come up with a case that you are all through unemployed.
That's
Neither pleading nor any evidence.
evidence is there. I have
Therefore
taken
ତାହେଲେ କଣ କରିବା? Remand କରିଦବା. ତାହେଲେ remand କରିଦବା.
amount is very
ଆପଣଙ୍କର pleading ହିଁ ନାହିଁ. ତେଣୁ remand କଲେ ବି କିଛି benefit ହବନି. Evidence cannot go beyond pleading.
and so far the management is also
କାହିଁ ଗୋଟେ
concerned.
fight କରୁଛନ୍ତି? ଆପଣ କୋଉଠି କାମ କରୁଥିବେ?
ନାଇଁ ମୁଁ ବଦଳିଆ
ଆପଣ ଘରେ
ମୁଁ
ବସିଛନ୍ତି?
ଯୋଉ ଲିମିଟେଡ ପିରିୟଡ ପାଇଁ ବଦଳିଆ ହିସାବରେ କାମ କରୁଥିଲି. It's true.
ବଦଳିଆ ଆଉ କଣ ହେଲା? 50,000 ଦେଲେଣି. ପୁଣି 6% interest ରେ ଦେଲେଣି.
ନାଇଁ ଦେଲେଣି ଯେ ସେଥିରେ ସେମାନେ 50,000 by I have worked more than 5 years. My juniors are still working and unit is running. It is Oswal and IFCO. And they are in need of
You understand the consequence. If we admit, it will come after 15 years. You understand the consequence.
Can it be raised to that extent?
So whether you are
That is-
helping your client or you are putting the client to further loss.
If at little be a reasonable
10
enhancement.
ବର୍ଷ ପରେ ଆସିଲା ବେଳକୁ
conscious
ଆପଣଙ୍କୁ ଆଉ
madam.
reinstatement
ନାଇଁ I am conscious. So far the ନାଇଁ ସେତେବେଳେ ମୋ ସମୟ ବି ନଥିବ ବୟସ ବି ନଥିବ.
admit କରିଦିଅ. Admit call for LCR.
And at that if reasonable enhancement will be there, that
ଏବେ କଣ ଆମେ କରିବୁ? You are not satisfied with an award. What more we can do? We can maximum entertain the application to hear the employer. So ଯେତେବେଳେ
And,
hearing ହବ,
and Mr. Mahanti, they have not challenged
as of now it is
because you see their written statement.
No.
Then you will realize with your experience that actually this 50,000 is a benevolent gesture
and they
because you two of them had earlier adjudication. Oswal is not a party.
Oswal is a party.
No. You
ଆଉ ଯେତେ
ସେ ଆର
କରିବେ
case ରେ
ସେତେ
ନଥିଲେ।
ଉପରକୁ ଯିବେ।
the problem is that perhaps so the 50,000 is kind of a benevolent gesture. ଆପଣ ସେମିତି 10,000 ଟଙ୍କା ଶୁଣନ୍ତୁ ଆପଣ ଯୋଉ 50,000 ଟଙ୍କା ଆପଣ ଏବେ ନେଇନାହାନ୍ତି ନା ପାଇଛନ୍ତି?
ନାଇଁ ନାଇଁ
ତ
ଦେଇନାହାନ୍ତି।
ଆପଣ ସେ
ସେମାନେ ଦେଇନାହାନ୍ତି।
ବଢିବ ଯଦି 5 ବର୍ଷ ପରେ 60,000 ଟଙ୍କା ହବ
କଣ ଲାଭ ହବ?
is no use. money
ଆଜି
gets
ସୁନାଟା 50,000
devalued.
କିଣି ଦିଅନ୍ତୁ।
Money gets devalued.
I'm conscious, my lord. If at all reasonable,
But
it can enhance also.
And more
Can
to add,
challenge କରିହବ?
and more to add, you will now invite the further employer to have a challenge to the award. Eta
They
ଦେଖନ୍ତୁ
can
ଆପଣ
also
music-
challenge it because at the earliest I have challenged it. It's
ଆରେ ଆପଣ କରିଦେଲେ ତାଙ୍କୁ କଣ ଆମେ ମନା କରିଦବୁ?
Petitioner ତାଙ୍କର ସେ ମାନେ difficulty ଅଛି ମାନେ workman ର always any employer has that is better equipped to raise a litigation.
They can also.
I never
come to a
take
different
a
compromise.
credit of my experience. But with my experience, you will face the music if you go out this litigation. ଆଜି ଲେଖିକି ରଖି ଦିଅନ୍ତୁ ଯେ ବିଶ୍ୱନାଥ ରଥ ଜଜ୍ ଥିଲା ବେଳେ ଏହା କହିଥିଲେ।
My lord has a long experience in this
ମୁଁ
particular.
କହୁଛି ପରା ଆପଣଙ୍କୁ ଆଉ brother ଯାହା sitting
No,
are
no,
and he will
your
not wear a gown. He
your
will, sorry.
your lordship,
This is not
I
discussed.
always appear
These are all-
physically.
these are all already we have spoken lot.
I am
Please.
unwell, my lord. I am
Please
suffering
don't
from fever,
humiliate
my
us.
lord.
Don't humiliate. This is 100th order of myself personally speaking.
My lord, may just give me
He
pardon
told
for
you,
once.
Please, my lord.
If you have
Next
the
week-
luxury, pay to the Bar Association Welfare Fund.
In this case,
My lord, only
I have
difficulty,
challenged
my
the
lord.
order passed by the learned
All-
ombudsman, my lord, under Annexure 8. The order of the ombudsman is under challenge and
Order of
Annexure 8,
Ombudsman.
my lord.
You are the
Where-
consumer.
My lord. But where my dispute before
Just answer 8 you are challenging.
my lord,
Where is the certified copy? Achi, it is there
my
already.
lord, my lord.
So
Page
what is your
34.
ground?
But my ground is that, but they have rejected my application on the ground that it is a case under 126 of the Electricity Act, and as such, I am supposed to file appeal under 127, my lord. But my humble submission would be, so far as the present case is concerned, Lord, my respectful submission is there is no order within the meaning of section 126 of the Act.
He has an indication of appeal provision available.
Yes, my lord. But I admit that. I bow down to that fact. But provided that is an order under section 126 of the Act, I have a remedy under section 127 under appeal.
Right, right.
Lord, here is a case where Lordship knows section 126 provides for all mandatory provisions. It has to be assessed. The provisional assessment order has to be served on me.
So, Mr.
Subsequently,
Sahu, please answer that.
Right.
Please be conscious of the query of the court.
Right.
See,
Right.
the appeal is before the commission.
yes, my lord.
And here this ombudsman is a subordinate entity as far as the hierarchy is concerned.
My lord.
So how can he adjudicate that? It is just possible if you
Yes.
go there
Yes.
and file that appeal.
Right.
They may say that we will remand it to the
Oh,
commission.
you are not remediless.
You are,
My lord, I bow down to that fact.
I mean,
Lord,
it-
but I-
what order you can get here in High Court?
My humble
We will
submission-
adjudicate
subject-
whether it is a 126 or 127.
No,
Or the commission will adjudicate that.
but the sole question, Lordship may
Sole
appreciate.
question, please don't
Right.
avoid the question. Sole
Right.
question that whether you are avoiding or answering the query.
Lord, I admit that I have a remedy of appeal, provided the
So
order
in
is under
226, in 226, how far we can go? How can we set aside a order which is on the face of it is correct?
Lord, my respectful submission.
At best, you can get an order.
Difficult, Mr.
The
Counsel.
limitation part will be
Difficult
taken
to
care of.
ascertain.
Fine.
Better withdraw and avail other remedies available to you.
Lordship may.
Don't take a negative order.
My lord, no, that is true. But so far as the limitation part is concerned, they have
Oh,
not.
we
Lordship,
will permit you.
Lord, my,
That 127 limitation achi.
but nahi,
Check question.
my, it is not there. That
That
is-
is then
Kahin apprehend କରୁଛୁ?
why you are
Within 30 days-
na bhai mujhe maar.
Within 30 days, I am supposed to file.
Okay.
But
କୋଉଠି ଅଛି? Limitation କୋଉଠି ଅଛି?
they something 126.
127 ରେ limitation ଅଛି?
But one, yes, my lord.
Okay, okay, all right, we can add few words. There's no issue. All right, you are bona fidely pursuing your remedy. At the submission of counsel for the petitioner. The petition involve order at unnecessary rate. Considering the points raised. And also, and taking into account the reasoning in rejecting. The attempt of the petitioner on the question of jurisdiction. This court find there is reasonable.
ଆପଣ ଏଇଟା କେତେ ଦିନରେ ଫାଇଲ କରିଛନ୍ତି? ଚ୍ୟାଲେଞ୍ଜ ଟା କେତେ ଦିନରେ କଲେ? 30 days ନା ଅଧିକା ନେଇଛନ୍ତି?
In fact, I have not challenged because there was no order.
ଆରେ ରିଟ୍ ରେ ଯୋଉଟା ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି
My lord,
ଅମ୍ବୁଡସମ୍ୟାନ ଅର୍ଡରଟା
my lord.
ସେଟା କେତେ ଦିନରେ କଲେ ବା ଅମ୍ବୁଡସମ୍ୟାନ ପାଖରେ କେତେ ଦିନରେ କଲେ?
Order was passed on 18/5/2023, my lord.
So 30 days ପରେ।
My lord, 30 days, after 30 days.
ombudsman ପାଖରେ ଯୋଉଟା ଚ୍ୟାଲେଞ୍ଜ କଲେ
My-
ଅରିଜିନାଲ ଅର୍ଡରଟା କେତେ ଦିନରେ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି?
ସେଇଟା କେତେ ଦିନରେ କରୁଥିଲେ?
My lord, the original order.
ସେଇଟା ହଉଛି 11/10/21 ଆଉ 5/11/21 ର order. Your proceeding was registered in 22
My lord,
when it was filed.
My lord, the difficulty is that, my lord, that order has never been served, and the code provides that once the order is not served on me, it will be null and void.
ଆରେ ଆପଣ ଆପ୍ରେହେନ୍ସିଭ କାହିଁ ହଉଛନ୍ତି? ଆପଣ ଡେଟ୍ କହିଲେ ଜିନିଷଟା ବୁଝା ପଡିବ।
Yes, yes,
ଆପଣ କଣ କହୁଛନ୍ତି କି ମାନେ
my lord.
Null and void, once you say, why are you challenging such orders?
Lord, that is why I have not
Then
challenged.
don't challenge.
But I have not
Then
challenged.
don't challenge. Why have you gone to ombudsman? If you say it is null and void,
Lord, what has happened, my lord? They have
void
added
orders
the,
need not be challenged.
Lord, they have added the amount to
Don't
my
be so
electricity bill.
assertive.
But
Don't
they have
be so
added the amount to my electricity bill. The only
Absolutely.
dispute is billing dispute.
So therefore, you
could have-
have a scope to challenge.
Yes, my lord.
Now appeal remedy is there.
Right.
Nobody denies. And
Right.
once a commission says, ombudsman says this, you have also come up against 126. ଆପଣ provisional assessment ବିରୁଦ୍ଧରେ ଆସିଥିଲେ ନା ନାହିଁ?
My lord, nothing was served on me. That is my specific.
Then what is your cause of action in going to ombudsman even?
My lord, I had approached the grievance redressal forum because the disputes were regarding billing.
that shows that you have such a weak case. Those kind of merit arguments you can make before the commission.
Right.
It was not solved. I did not know. I don't have electricity. I don't have an agreement.
And yourself has annexed the final assessment order.
Lord, that was supplied only before the ombudsman and not before the grievance redressal forum. That
So
itself
you are
is-
now in possession.
My lord,
Now you have a remedy
now-
or not?
Yes.
So
yes,
argue on that. Be
I bow.
positive.
Yes, my lord. Yes,
ଆପଣ ସବୁ negative argument
yes, my
କରୁଛନ୍ତି.
lord. I bow down.
This was not the case when you went to ombudsman.
Right.
Now you are in possession. You have
Right.
filed this document.
My lord.
And this is available.
My lord. It is there.
What are you arguing?
Right.
ମୁଁ ଜାଣିଛି ଦାସ ଆସିନାହାନ୍ତି ଆପଣଙ୍କୁ ପଠେଇ ଦେଇଛନ୍ତି ଯାହା କୋର୍ଟ ସାଙ୍ଗେ କ୍ୱାରେଲ କରିବୁ କିଛି ଗୋଟେ ମିଳିଯାଇପାରେ କିମ୍ବା କୋର୍ଟ will lose its mind and may give some petitioner wants to withdraw the writ application, pursue his appeal remedy for already in possession of the final assessment order appended to the writ application by page 33. Okay, this court permitting with dismissing the writ application, however, with liberty of appeal, observes in the event petitioner justifies that he got into possession of the final assessment order, page 33, only in the course of proceeding before the ombudsman. Limitation, if any, in preferring the appeal. Considering the limitation aspect, the appellate authorities shall do well in also taking into account the above aspect before passing any order in the limitation.
One more prayer subject to lordship's consideration.
Appeal may be preferred within 2 weeks.
My lord, till then, my lord, since they have issued a notice for disconnection, my lord, that is under annexion 9. Lordship permits, my lord, till filing of appeal, lordship. Till filing of appeal, my lord, they have issued a notice for disconnection, annexion 9.
Immediately file.
My lord, I'll file, my lord, till then. my lord,
If the petitioner is still, the petitioner premises is not still disconnected, there should not be disconnection. Final assessment re kete toka heichi?
my lord, 2,52,798.
Statutory liability kon appeal file kale?
50%.
So you deposit 50%, provided the petitioner files an appeal and deposits the statutory liability of 50%. Along with appeal, along with receipt on depositing 50% as per the statutory liability involved herein. There shall be no disconnection till the appeal is finally adjudicated. ସେଇ ତ ଦୀପଦ ଛିଡାଇ ପ୍ରଥମରୁ କହିଥାନ୍ତେ ଅବଶ୍ୟ ବାର ଇଜ ଏନଲାଇଟେନ୍ ଆପଣ ଆର୍ଗୁ କରିବା ଦ୍ୱାରା କିଛି ଡିସ୍କସନ ହଉଛି ଖାଲି ବାର ନୁହଁ ଆଜି ଆମେ ଗଲେ ଦେଖିବୁ 800 ଦେଖିବା ପାଇଁ ଖରା ବେଳେ
Item 6, my lord, in
ଟିକେ
response to
ମାଇକ ରେ କୁହ
In response to my lord's order, I have already filed the jointness affidavit.
ଆପଣ ମାନେ ସିନିୟର ଓକିଲ ହେଲେଣି ବୟସ ଆପଣଙ୍କର 25 ବର୍ଷ ଓକିଲାତି ହେଲାଣି ନା ନାଇଁ
ଆଜ୍ଞା
ହେଇଗଲାଣି ସବୁ ତ ଧଳା ଦେଖାଗଲାଣି
by their fathers.
ଫାଦର
return.
ରିସିଭ କଲା ଝିଅ
ପରେ
ବାପା ପାଖରେ ରହୁଛି କି ଆପଣ କାହା ପାଇଁ ଆପଣ ହଜବେଣ୍ଡ
ନାଇଁ ମୋ wife.
notice was directed to be issued involving the limitation matters by order of this court on 30/6/23. Notice issued both way. Court process notice was received on behalf of respondent 1 by Sri G. Ponda. G. Ponda father ତାଙ୍କର
ଯେଟା ଭୁଲରେ ଲେଖା ହେଇଯାଇଛି ତାଙ୍କ ବାବା ନାଁ ହଉଛି
ଲେଖିଛନ୍ତି
ଆଜ୍ଞା in my affidavit I have
ବାପାଙ୍କ ନାଁ କଣ ଜି ପଣ୍ଡା ଗୋପାଳ ନା କଣ
ତାଙ୍କ ବାବା ନାଁ ହେଲା ନମରତ୍ନ ପଣ୍ଡା।
ଆସୁନି ତା ବାପା ତ ଆସୁନି
ନା
ବାପା ଗୋପାଳ ପଣ୍ଡା ନୁହଁ
but noting has been come from
ତାହେଲେ
the
କଣ
processor
ହବ
but that is G Ponda.
ଜଏଣ୍ଟନେସ୍
ଆରେ ତାହେଲେ
ହେଇପାରିବନି
ତ ହେଇ ବି ପାରିବନି ଆପଣ ତାକୁ ଦେଖିଲେନି ଫାଇଲ କରିଦେଲେ
ହଁ
obviously ଗୋପାଳ
G
ପଣ୍ଡା is-
Ponda, there is nobody else in their family.
Then
G Ponda.
how can you presume that his father has received?
ଟେକ୍ ଆଉଟ୍ ପେପର ପବ୍ଲିକେସନ ଏଇଟା ଝିଅ ପିଲାଟା ପୁଣି କଣ କରାଯିବ
Delay is
G
on
Ponda ନା ତ କିଏ affidavit ଦେଇଥାନ୍ତେ who is G Ponda staying there?
90 days is to file.
ଆରେ ତା ବାପା ହେଲା ନମରତ୍ନ
Namaratna Panda.
ଆଉ ସିଏ ଜି ପଣ୍ଡା କିଏ ରଖିଲେ କେମିତି ହବ Okay, this court find there is no proper service of notice in spite of jointness being filed. As father name is not telling with the person receiving such notice. ये किए ये ହେଲା ସୁଦୀପ୍ତ ହଉଛି
Sudipa ହେଲା
ସୁଦୀପ୍ତା
Sudipa. Why?
ସୁଦୀପା ଏଟା କଣ guardian purpose
Mila.
on the next date of posting on 25th of July. Done. କୁଆଡେ କଣ ମୁଣ୍ଡ ଖେଳେଇବ
My lord, I'm praying for 1 week time for fresh step. For fresh step, sir.
Non-claim deed all right. You are also wife.
Sir.
Okay, fresh notice on the request of the wife involved within on sole opposite party on requisites being filed by day after tomorrow.
My lord.
Yes, notice be issued. Fixing short returnable date matter to be placed after appearance of parties or service report on such notice being availed, being prepared by the registry of this court. Interim order କିଛି ଅଛି?
No, sir.
All right.
Item 8. Item 8.
I pledge to Lordship, I am on VC.
Pardon?
May I please your Lordship, I am on VC.
You are on VC in item 8.
Yes, sir.
For opposite party?
Yes, sir.
For opposite party?
Yes, sir. For opposite party.
Your name, Sandeep Kumar Patra.
Yes, sir.
Where is your appearance memo?
Yes, sir. Yesterday I filed vocal number, sir.
Your file, vocaler.
Yes, sir.
Online file got yesterday.
ତାଙ୍କ ନାଁ ସାଙ୍ଗରେ ଆସୁ
Yes, my lord.
Your voice is breaking.
My lord.
What is the defect? What is the Noting here,
Millard, the order dated 11/5/23 may kindly be seen.
4 demand drafts amounting rupees 3,000 only has been filed by counsel for prisoner in late. Tak accept kar dava.
Yes, my lord.
Accept kar dava.
2 lakhs was
So
deposited in
that will
time.
dispose the extension of time.
That means
will
case,
automatically dispose. Now in the meantime, he has already appeared.
my lord,
You are for husband.
my lord.
जो टंका deposit कौन? What was the reason for depositing?
My lord, the Lonet Family Court, Berhampur, has awarded alimony amount
Here the direction. What was the direction?
The
regarding
direction-
payment by this court.
by my lord.
Kete ko order ta?
11/5, my lord.
Yes.
11/5/23. While admitting the appeal and directing issuance of notice.
Sir.
Order number 3. Date होचे 11/5. Order number 3 रे अच्छी से direction. What was the amount directed? No, not by this court. Finally, the
My lord,
family
10 lakhs. 10 lakhs, your lords.
10 lakhs.
10 lakhs.
And the court has directed for deposit 3 lakhs.
3 lakhs, my lord.
Okay.
I have complied.
You have come. You have. Who had gone to the family court? Husband
Husband, my lord.
for divorce.
Divorce.
So
Prior
this
to
is
that, there
only
was.
on the aspect of compensation.
Yes, my
or
lord.
permanent
Quantum,
element.
quantum only challenge.
You have challenged quantum only.
My lord.
Release कर दे तब.
File kole extension ta sir.
My lord, my lord.
केबे केते दिन भितर करिवार थिला? Because that's a peremptory order.
6 weeks time was
You have
given.
to
my-
go to that bench. Strictly speaking,
Yes, my lord.
we can't extend. आपण 6 weeks भितर file करछन extension टा.
First 2 lakhs was deposited. Yes,
Nahi,
yes, 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 yes.
Date टा कोन तो आपण
19/6, my lord, 19/6. 19/6/23, that is 2 days before expiry of the time.
IA number
IA number 199 of 23, my lord.
199. 19/6 रे फाइल करछ.
My lord. 21/6 रे मो टाइम सरी होतला.
Yes, Mr. Counsel, can you hear us, Mr. Patra?
Yes, sir.
So he
No.
has already made the deposits.
No deposits. No deposit. There is no.
Release in.
Arey, how do you say no deposit? It is in the custody of the registry. How do you know that?
They are
even?
holding that.
Please be conscious what you are saying.
No, sir. The
How
in
do you
family,
know that it has not been deposited when it is on the record?
no, sir, in family court is not deposited. We have not received any
No,
information.
that's
No,
not a
it is
direction.
on record.
Family court, there is a direction to deposit in family court.
No, no, no. Before here, my lord.
No, then Mr. Patra, you are wrongly instructed. Have
No,
you
no.
checked the order? 11/5 order, have you checked? Where is the
Only, sir.
direction to deposit in family court?
No, sir. Only MAT copies with me, not the IA copies with me, sir. Only MAT copies with me. MAT 1/1/2023 copies with me, sir.
At the submission of Sipotna miscase record. The last miscase jotare ki kohunti condonation of
199 of 2020.
Hala?
X-ray.
On perusal of demand drafts presented before the registered judicial Orissa High Court Cutter. Their drafts appears to have been prepared on 14/6/2023, remaining valid for 3 months from the date of preparation. Hala? This court finding amount was deposited because the short hours. ସବୁ ମିଶିକିରି ହଉଛି 3 ଲକ୍ଷ ସବୁଗୁଡାକ 3/7 ବରଂ ତାପରେ 4/7 5/7
First draft was deposited or in time?
This court finding there is already deposit. First draft टा बोधे थिला 2 लाख ର थिला नहीं first
My lord, my lord.
2 लाख ର तापरे खुचरा deposit
Yes, my lord.
आउ लक्ष टंका deposit कले
My lord.
in 4 drafts ala
Yes, my lord.
4 drafts, one for 2 lakhs, the others are 40,000, 35,000
And 25,000.
25,000 respectively.
My lord.
Finding there is already deposit of the amount under direction, this court accept the application by way of accepting the drafts deposited herein. The Registrar Judicial is directed to invest the amount immediately in the account of the registrar, High Court of Orissa, Registrar Judicial, High Court of Orissa. And in order to release of the whole amount in favor of the wife by making a draft. The cost of the draft.
Account detail dele RTGS
It all right. Okay. To be released in favor of the petitioner on the account details being furnished by Sri Patra to be released in favor of the opposite party. Opposite party by on the account details being furnished by the opposite party wife within a period of 7 days hence.
But what a memo ta online upload karibe, Mr. Patra. Did you hear the order passed by the court?
Yes, sir.
Yes,
The
sir. Give the details.
registry of this court.
At least enclose the photocopy of the first page of the passbook
Okay, sir. Okay.
along with photograph of the lady.
This is the details, bank details of the opposite party. The registry shall do well in remitting the matter to the account of the wife in the furnished account details under the RTGS provision and put up a note before this court. Right, miss case main case there is already appearance on behalf of the wife by Sri Sandeep Kumar Patra appearing VC Ganjam, Barampur, who was stated to have already transmitted the Vokalatnama with appropriate dues to the registry of this court. Registry to find out, name the counsels in the next listing of the matter on 28th list hearing. 28th will hear the matter. It is only on the quantum aspect.
Okay, sir.
Acha, in the meantime, decision on the affidavit
Rajnish versus
Rajnish versus
Neha.
Leela.
NEH.
Neha. In the meantime, husband is also directed to furnish affidavit in compliance of the directions in Rajnish, in the case Rajnish versus Neha, citation ta de do hala. On a copy of the same being also served, within 1 week karibo, on a copy of the same also being served on the counsel for opposite party,
My lord.
who is also at liberty to file his response to such affidavit by the next date of posting. Hala apana eithre se jo details achi se details debe,
My lord.
tanko copy de debe. If they inquire, they find a objection, jodi au kichi adhika property apangar achi dekhele ei sabu ku dhari kiri ame decision nabu.
My lord. My lord.
Au come with a bona fide attitude.
My lord.
Hala, be benevolent.
Yes,
She is
yes.
your wife.
Yes, yes.
She is not challenging the divorce.
No, no.
You are only challenging the quantum.
My lord.
Therefore, quantum re, there should be a good settlement.
Yes. My lord, IA 136 of 23 is a further extension of interim order.
Interim order is and extended to continue till next day.
My lord, obliged.
For admission item 9,
May physical ଅଛି Lossi kindly see the last order schedule ଅଛି
address नहीं आउ थे notice नेबे Oh, Cheta also reported. It is 21. No, it is 21, sir. Right. 1, No, citation the lekhi diya. Air 2021 Supreme Court 569 bracket rakho 2021 bracket 1 OLR Supreme Court 345.
8, sir.
Yeah. Yes, notice is not sufficient probably.
My lord
So you will take fresh notice.
my lord 7 days time में भी
But
kindly
is there any already appearance of such parties?
I am appearing for OP number 5,
OP5.
my lord.
Then this is notice on OP3.
Three.
A contesting party.
my lord he is the contesting opposite party why I am he is the contesting opposite party
Contesting.
the contractor ଅଛି
Nobody has appeared for OP3. 1 and 2 appear karchandi, 4 appear karchandi, 5 appear karchandi.
Yes, only 3.
5 kiye, no, 3 kiye.
Branch
the
manager.
branch manager Orient Security Solutions Private Limited
All right, it has a stake.
My
It has a stake in the matter.
my
All right, considering OP number 3 has a stake in the matter. And there is no service of notice on OP number 3 as of now. This court direct press notice on OP number 3. What is the dispute involved?
Lordship, I have challenged the order of reference at annexure.
Order of reference.
Your Lordship. Because that is beyond to the scope of complaint petition and the failure report, which is prohibited
Order
under
of reference and 8 years have passed.
my lord.
8 years have passed.
My lord. Your Lordship has a glance to one line only.
Then you take out paper publication notice. 8 ବର୍ଷ ଗଲାଣି ଆଉ କେତେ ବର୍ଷ ଆମେ notice absent ଅପେକ୍ଷା କରିବୁ? You are in luxury. This is state. So you are in luxury. All right, considering the writ petition is pending since 2015, involving a challenge to order of reference also issued in 2015 to not to lose any further time. This court direct the management petitioner to provide notice to the OP number 3 by way of paper publication. Bringing out a paper publication as against OP number 3 within 2 weeks. Hala. ये कर दो लेकिन वो draft notice be filed before registry by Friday.
Lordship, kindly some more time. By what day?
By Monday.
On Tuesday, Lordship. By Tuesday. By Tuesday, Lordship.
इतने दिन कौन हो बापों तो इटी बसिगिरी से देखिबे लेखा पेपर रे सब दिन ऑर्डर 5 रूल 20 नोटिस
खाली क्लाइंट को टैग करेंगे
अरे सीए पब्लिकेशन करिवे ता पई कोन पैसा धरि के आसीबे फीस आपण देबे बिल देबे से देबे आ इत्ते काई वीडियो होचंती
मंडे था
सकाळ केस रे मन दुख होई जईजी
टिके परिश्रम करथिल टे स्टैट्यूटरी प्रोविजन टा टिके सर टिके देख
बाय ट्यूसडे एज अंडरटेकन Nana. The draft may be approved by Friday. Publication ta 2 weeks rehava. After the publication is made, let 3 copies of the same be filed. Aji gala 12, 14 din gale, 2 weeks gale 26 gala. Tenu asu 31 tarikh re asibo. May have to be listed again on 31st of July.
Interim order to continue. Interim order to continue.
Interim order to continue. Yes, you are enjoying the interim order. Reference re haba na haba ta upare rahigani litigation 8 ବର୍ଷ କେବେ adjudication haba.
Oblivion.
Yes, next.
Item 10.
अच्छा 12 ବାଜିଲାଣି ଉଠିଯିବ Any
Madam, in this
dispute here, there is already compromise?
No, madam. In this
Nice.
case, I am.
ନା ମ ଆପଣ କଣ ସବୁ ଓକିଲଙ୍କ ପାଇଁ କହୁଛନ୍ତି?
No, madam,
ଓହୋ।
I am.
Okay, all right. ଏଇ ଯୋଉ 20 ଯାଏ ମ୍ୟାଟର ଅଛି ଏଗୁଡାକ ଆସିବ ଲିଷ୍ଟ ରେ।
I am applying for open work for madam. 17B has not been complied with, madam. 17B has not been complied with,
କୋଉ
madam.
କେସ ରେ?
Item 10, madam.
Item
10, madam.
10 ରେ?
Madam.
Item 10 ଟା
How did it pass through?
ରୁହନ୍ତୁ। କଣ what is the direction of this court? There is already an order for complying the
Miscase was, he has
okay,
filed.
service karo କହିଲେ order କେବେ ହେଲା?
Miscase 16305 of 2017 on dated 21/6/2018 that has been already.
Yeah, there is already order.
Already disposed of.
But they have not complied, madam.
Oh, they have not complied. Then what is the responsibility?
44,000 already paid.
ରୁହନ୍ତୁ 17B ଦିଆଯାଉ ବୋଲି କୁହାହେଲା।
Madam.
ଯଦି ନଦେଲେ
ହଁ।
ତାହେଲେ କଣ କରାଯିବ?
File execution, I have already filed, madam.
Execution so it will be taken care of in execution.
They have not proceeded with.
Oh, ଆରେ ସିଏ କଲେନି ରିଟ୍ ରେ ସେଇଟା subject.
No, madam, when this
So
matter is pending, that's why.
please, you pursue your execution remedy. ସେଠି attachment ଅଛି।
They passed that order that since the matter is pending in High Court, we are not proceeding.
No,
So they cannot pass that order.
no.
You can always execute, these properties will be attached.
Our duty is over. 17B to be complied.
Madam.
Execution file କଲେ।
No.
Execution କୋଉଠି file କରିଛନ୍ତି?
STGM court.
ହାଁ?
STGM court.
ଭଗବାନ। ଏ ଆପଣଙ୍କର ଜ୍ଞାନ?
Labor court.
Labor.
High Court order execution କୋଉଠି ହବ?
Wrongly filed.
ଆରେ SDGM କୁ କାହିଁକି ଯାଉଥିଲେ? section 29 ରେ ଯାଇଛନ୍ତି?
Madam.
29?
Madam.
ହଁ 29 ରେ କାହିଁକି ଯାଉଥିଲେ? Here High Court order is not complied.
Madam.
It's admitted dues 17B.
Madam.
ଯାହା ଟଙ୍କା ସେତେବେଳେ ପାଉଥିଲା it's already determined.
Madam.
High Court ରେ register ରେ ହବ, register ପାଖରେ execution file ହବ, it is early easy process. ଆଉ ତା ବି ଆମେ ବତେଇବୁ ଆପଣମାନଙ୍କୁ।
I'll file.
ହଁ ଯାଆନ୍ତୁ ଆପଣ advise କରିଛନ୍ତି ଆଉ ଆପଣ criminal lawyer
I
ବୋଧେ?
have not advised.
criminal lawyer ବୋଧେ?
No, madam.
ଆଉ SDGM ଏତେ ବାଟ କାହିଁ ଯାଉଥିଲେ? ସିଏ ତାର ତ ତାରିଖ ପେ ତାରିଖ।
Madam.
Award ଟା ପାଇଁ କରିଛନ୍ତି, but there is a order in the IA
Madam.
that my lord was referring.
Madam.
So that is to be
ହଁ
executed in High Court only.
sufficient indication ଦିଆ ହେଇଗଲା।
Madam.
40,000 ଦେଇ ଦୟା କରିନାହାନ୍ତି।
ଆଜ୍ଞା।
ଆପଣଙ୍କର ଯାହା ଅଛି statement ଟେ କରି execution file କରିଦିଅନ୍ତୁ registrar ପାଖରେ।
I will.
registrar judicial।
Madam.
ଦେଖନ୍ତୁ ଗୋଟେ execution proceeding High Court rules ରେ ଅଛି provision।
Madam. I will.
ହେଲା? ଏଟା ପଢିକିରି ସେ ଅନୁଯାୟୀ file କରନ୍ତୁ, court fee is not necessary।
Madam.
ଏଟା file ହବ, attachment ହେଇଯିବ, ତାଙ୍କର କଣ account ଥିବ attachment ହେଇଯିବ, ନହେଲେ managing director ଯୋଉ ଗାଡିରେ ଯାଉଥିବ ସେଇଟା attach ହେଇଯିବ। next ହେଲା ଏଇତ କଥା। ଆଉ ବାକି ମାଟା କେସେସ୍ ଶୁଣ, ମାଟା କେସେସ୍ ରହିବ ଲିଷ୍ଟରେ ହେଲା। ଆମେ 12ଟା ପୂର୍ବରୁ ଯଦି ହିୟରିଂ ହବ କରିବୁ। ଆଉ ବାକି ଏ ଯୋଉ ମାଟା କେସେସ୍ 21, 22 ये सब रिलीज ହେଇଯିବ out of list। ଆମେ 20 ଯାଏ ସାରିଲେ ये मैटर लिस्ट को आसीबो। one thing you may find court master, या ଭିତରୁ ଯଦି କୋଉଥିରେ ନୋଟିସ୍ absent ହେଇନି ତାହେଲେ ତାକୁ ଅର୍ଡର୍ସ ରେ ଆଣି ହେଲା। ଏଠି ଦେଖୁଛୁ ଆମେ ଲେଖା ହେଇଛି କିମ୍ବା डिपोजिट ହେଇଛି, डिपोजिट ର କଣ କରାହବ ଗୋଟେ କେରେ ଅଛି 8 lakhs have been deposited by learned counsel, registry seeks some direction, एवढा ऑर्डर्स नहीं आसीबो ହେଲା। एटी
The part contempt.
Yes, my lord.
Past contact, all right. Hmm.
Item number 2.
This one not showing interest. This is for non-prosecution.
Item number 3.
Not showing interest.
Here, Lord, we have filed the counter.
You have filed counter.
Yes.
State Council submits there is already filing of counter, which is not on record. Rest is directed to place the matter next Wednesday, but along with the counter. In the meantime, copy of counter be served on the council.
Yes,
for the
council,
petitioner.
I would have sought today, they're not there.
All right. Next.
Item 4.
My lord, item 4 on behalf of Mr. Roy, my lord, I'm appearing from this.
Yes.
My lord, may I pray for a Passover, my lord?
Passover name, aji early rise karibi. Let it come tomorrow.
Your lordship.
Tomorrow.
Item 5.
This is regarding, Lord, a meeting which was supposed to be convened by the sub-collector on the basis of an allegations made against the present petitioner who is operating a petrol pump, my lord. In this connection, there is another PIL, which a PIL has been filed that is pending before the lordship. And at the same time, my lord,
PIL on the same
same issue.
retailer.
Actually, the allegation made by the persons who are agitating that PIL, my lord, the allegation that he has violated certain norms and conditions of the
Then you do one thing. You can approach the learned, the PIL bench.
bench. It is
for
there.
taking this matter along
Yes.
with that.
You can do that.
It is
And
better.
for stay is there, it is continuing.
It is reported that involving the self-same issue, there is PIL wide case number ଗୋଟେ slip ରେ ଦେଇ ଦିଅନ୍ତୁ.
ଅଛି ନାଇଁ annex
Right,
କରୁଛି.
so and so ହେଲା.
କେତେ number ଟା ଦେଲ?
ଦେଖିଦ PIL number ଟା ଗୋଟେ ଅଛି କି.
It is annexure 7, my lord.
For this matter placed in single bench, annexure 7 ରେ PIL number ଟା ନବ ହେଲା. This being a single bench matter, it is better petitioner approach the PIL bench for accommodating also this matter to be disposed of along with the PIL to avoid any confronting decision. Any confronting decision.
My lords, may I play the interim order?
Conflicting decision. No.
Interim order to continue.
Interim order there.
Yes.
My lords,
Okay,
Meeting has not been convened pursuant to your lordship's direction. That
interim order to continue.
I am deeply obliged.
Yes, item 6.
Item 6.
Item 6, my lord, probably the counsel for the petitioner is not there. But here in a most identical matter, since I undertook to appear for the opposite party number 4,
That is disposed.
you will also pass this order.
But counsel nahanti petitioner. No.
You will also may kindly see that. Here.
Dekhiya Monday aniba. Asu, counsel, you are appearing for private opposite parties.
Yes, my lord.
Dear.
You will also
The
pass.
Das learned counsel appearing for private opposite parties herein submits. अच्छा ସେଇଥିରେ ବି notice ହେଇଛି
ସେଥିରେ ବି notice
ତ
ହେଇଛି
same order ହବ
same order ହବ
all right same a order କରିଦିଅ ଛାଡିଦିଅ ତାପରେ read ରେ ରଖିବ this matter is to be listed along with WPC 15461 of 23
my lord.
ସେଥିରେ ବି interim order ଅଛି so any further interim order is necessary
No, that also.
or that interim order will cover this case.
Yes, my lord. That civil suit and same, that is also the property involved in
For
that.
there is already stay order, stay involving civil suit number so and so. In IA number so and so, in WPC number so and so. There is no necessity of further interim direction.
1546.
The IA stand disposed in, but in terms of IA number so and so, in WPC number so and so.
My lord.
Yeah.
Item 7.
Dispensing टा भी allow कर दो ची Mr. Das. Dispensing टा same इस case रे allow कर दो. मेरा IA 711 of 9. Certified copy of the impugned order already available. in WPC number so and so. This court allows the application and dispense filing of certified copy of annexure so and so herein. Our direction to higala eta ta sangere asibo bole.
Again.
Okay, yes, 7.
Counter time file कर दीजिए.
Counter. State Council submits is already, she goes, filed counter, but no such counter is on record. Registry directed to assemble the counter on the next listing of matter on next Thursday, next Wednesday. Non-appeals kari kariba. Na interim order achi ki? Interim order thile continue kariba. Dekhi rao.
Item 8.
May I please, Your Lordship? Your Lordship, may I kindly look at the earlier order, order number 3 dated 5/7/2023, my lord. Here the state was to-
Subhani.
I'm sorry, my lord. Your Lordship kindly looks at the order number 3 dated 5/7/2023, my lord. According to that order, the state was to submit a small affidavit, my lord.
We have filed it. Copy will serve.
Copy 9.
Copy टा देबो.
Yes.
So
Yes,
process.
after so much development, what is the fun of entertaining such a litigation?
That's why copy has not been sent.
आगे सेटा सॉरी वाला नहीं बोले शुक्रवार दिन सब सॉरी जो.
Don't fight this litigation.
Your Lordship, then
Sorry. Suno, lani car burial ground re,
my lord.
5टा लोगों को oppose करी परे, 50टा लोगों को support करी परे. And there is already lot of investment. Plinth construction सरी गलानी, लक्षे 12,000 टका खर्च होई गलानी.
सेटा तांका फेवर रे ही.
Yes.
That is in their favor.
Let a copy of the affidavit be
Okay,
served
for the
and
development already taken place involving the burial ground appearing through the counter affidavit of OP number 4. This court find no purpose in entertaining such litigation, which is dropped accordingly.
at least copy of the affidavit be sought on me. The read petitioner it is for yes. Obliged, my lord.
Item 9.
9, my lords. Is that secretariat pass, which was supposed to be renewed, pending. The lordship were directed to give a to extra.
Secretariat entry pass, Mr. Das, Mr. Bose.
Again.
This is a regular phenomenon. Right, you have some security system, somebody must have a pass to gate entry, but I find people having already passed. Renewal is taking place 4 months time.
The direction would they don't to strictly comply kori set up.
Apangara kon, why you want to get inside the secretariat?
Steel and Mines Department रे more mines अच्छी deposit करिया पे.
You had already a pass.
Yes. Renewal पे है. Since
direction दे
2018.
नहीं मु एठी direction दे देले matter is not ending here.
ताले मु instruction काई नामे मगी थिलु instruction टा.
No, I am giving a direction to explain as to why this is taking. So, सुनो it is also similar case mu देखो जी. This man has a business to enter inside there. He has a requirement, compulsory requirement. And you don't renew his
Statutory requirement, not deposit करो.
Why this is taking so much time? Yes, if it is a new case, you may get the input through the intelligence, यार background कौन, यार history sitter की, या आसिबा उचित की नहीं. But there is already a pass in his favor.
एटा को 7 दिन पर रखंतु मु instruction नहीं है तो काहे की से माने.
Strange to observe that persons already having secretariat pass. Renewal of such passes is taking almost 3 to 4 months, creating great difficulty on the pass holder in entering inside the secretariat, even in dire necessities. This court finds strange in the considering the renewal applications at least. Thus direct the State Council to obtain an affidavit of the opposite party number 2 or an authorized officer indicating streamlining the process of time and measures in working out with the fresh application requiring entry pass to Secretariat, and also in the matter of renewal of the passes already existing, but last for the time period mentioned therein. Let an affidavit be filed within 7 days, 10 days.
10 days. What a free copy would
Free copy of order be handed over. Pendency of the writ application may not be construed in not attending to the call of the petitioner in the meantime. Yes. This is a regular issue.
And statute use they peribini.
ये अच्छा ता भीतर को तांगर जीवार भी बाटो ना
तांकर डेली गोटे अछि पास र सिस्टम अछि इफ यू हैव सम
काम कर दियंतु somebody is going, definitely there is a order for his moving inside.
Yes.
Some direction, some
सेटा सेठी देखेले से माने फोन करी पचारंती कंसर्न डिपार्टमेंट
नहीं आपण गाड़ी कर दियंतु से तांको गाड़ी बाहर थोई दे पार्किंग लॉट कर दियंतु आपण को गाड़ी एसो ता नहीं पळेबो से काई से लोक खोजिबे से लोक थर्ड फ्लोर को जाइतिबो से केतोळे आसीबो ताको अटेंड करिवो मु एग्जांपल दोची then he is hanging on there for 1 hour 2 hours. You have to also value his timing. Right.
Item 10.
If I may be pardoned to make a mention, your lordship. Item 6, your lordship.
Your turn is over. You find out the order. Non-appeals ta kati dabo na. Non-appeals ta kati dabo.
Same order you write la
Yes, next.
In this writ petition, I have challenged the order dated 2/5/2003 passed by the consolidated commissioner of the consolidated holding government.
You challenge Annexure 6.
My lord.
Where is the cost title of Annexure 6?
Monday.
It starts from page 31. There is no cost title. There is no case number indication. Come to page 31 because page 30 is a receipt.
Two divisional petition.
Mike, please be on mic. Please be on mic. Please be on mic. अरे बुझे दियो तो mic आगे रहियो पे कौन तू?
My lord, the officer giving that type of certified copy.
No. Then you have to give a. Why you should? अरे पार्टी किया हमें जानी होनी. को केस रे पास ही हमें जानी होनी. ताले आमे कौन करचो हमर यूजुअल प्रैक्टिस होची एटा पठेई देबु टू make necessary incorporations and send it. Till then we can't take up. So what do you propose? You will provide a certified copy with cost title, even case number not there, Mr. Counsel.
Sir, they have given such type of.
केमिति करिवु कोन तो आमे कोन काली Annexure 6 कहि कि इंटरफेयर करजु.
Sir,
so what do you propose?
Propose that the proper certified copy is to be necessary.
Let this matter 6 days after, in the event petitioner applies for a proper certified copy of Annexure 6 with cost title and case number. It may be provided within 4 working days. नहीं देखे किसी लाभ अच्छी कि से केस नंबर हुए
केस नंबर ता गोटे चिठी आकार अछि सेवन मो टिके देखंतु पार्टी नाम कॉस्ट
same जिनस तो आपण मते देई छथि. It is certified copy rather, but certified copy without having cost title nor even case number. Order date side रे टिके खाली 2/5 देखा जाउछि चलिबो. But what do we get the cost title, case number even? Let's the matter 8th day re karo posting. Yes, you inform these authorities why they supply this sort of certificate copy.
One repeat copy can be solved.
Copy भी देई ना.
Repeat copy service करना.
In the meantime, let a copy of the writ application we also, along with annexures, we also served on the State Council. Yes.
Item 11.
Copy that देई ना.
Item 11, I am appearing on behalf of Mr. Dayananda Mahapatra for Bhubaneswar Development Authority. In this case, one copy has been served to us. and we send the copy for instruction to the BDM, my lord.
Okay.
Humble submission, my lord, one more extra
Okay.
copy. is
What time you want?
7 days time, my lord.
7 days.
If a lordship.
Another copy just now, my lord.
Am I audible to
There
lordship,
is
lords?
already service of one copy. On Sri Dayanand Mahapatra, who usually appears for Development Authority Bhubaneswar. Counsel appearing for Development Authority seeks at least 7 days time for instruction. A further copy of the brief also being served on the Counsel for the Development Authority. Appearance along with counter, if any, be filed within 10 days. Registry directed to list the matter on after 10 days on so and so, also indicating name of Mr. Dayanand Mahapatra as counsel.
Well, my name may be reflected.
Much
Lords.
obliged.
Lords, in this case, I appear for the
Yes.
opposite partner two, my lords. Lords, I appear in this case, my lord, for opposite partner two. My name may be reflected in the cost list, my lord.
Your name is not there in the cause list.
No, my lords. No. I appear
No.
for the opposite partner
Have you
two. my
filed?
lords.
Have you filed your appearance memo?
Lords, I have already filed, my lords. Lordship may record myself.
Sri Das Learned Counsel appearing for Vigilance Department.
Yes,
For opposite partner two, my lords.
OP number 6.
Two, my lord.
OP number 2
yes.
My lords.
makes a statement that he has already filed his appearance office to verify and indicate his name in the next listing based on such appearance memo. OP number 2 is Tahsildar.
No, my lords.
He says in item 11.
Previous matter.
In item 11.
Egar padela ta sangre dekhi.
Item 11, lords, for OP number two, my lords.
Filed. Oh, jota arjan kar li.
Yes, yes.
Sorry, 11 de lekhi diya. Okay, all right. Yes, item 12.
My lord, on behalf of Mr. Mahanti.
Hey, bhalo, ye tag laga itri kon. Yes.
On behalf of Mr. Mahanti, this is a case for correction of the ROR. As per Narottama Ratha case, covered matter, your lordship has also passed the order.
There is already a read court direction.
Yes, my lord, your lordship has also. I'm sorry.
Annexure.
Annexure 2. Your lordship has also passed the order.
Annexure 2 page kon do.
Page 32.
Oh, ido division bench order.
Yes,
then.
yes.
All right.
Obliged.
Item 13.
Petitioner prays for expeditious disposal of the RP case number.
Reading already completed.
My lord.
Okay,
A case of about
considering
236.
reading in revision case, consultation revision case 258 of 2006 completed. And as this court find, there is long pendency of such proceeding. Direct the opposite party number so and so to complete the proceeding in consultation revision number 258 of 2006, at least within a period of 4 months of the date of communication of order. Second case also same.
Same revision ta number ta alga.
Revision case number ta change kar do.
Item 14.
May I please your lordship? Petitioner prays for quashing of the demarcation case, my lord. My lord, since
Quashing of the demarcation order.
my lord, demarcation case, my lord. My lord, kindly come to
Just come to where is the impugned order?
my lord, order not notice, my lord.
So demarcation notice you are challenging. Why?
My lord, since the suit is pending, my lord.
Suit is pending. Why don't
Pending.
you file an objection there? Not to proceed, asking him not to proceed. Why are you coming to High Court?
Since this
Oh,
honorable
you have
court,
the opportunity or not?
my lord, this honorable court in the opposite matter number 4, filed one WPC, I have mentioned page 5.
Directed, already directed to
already
conclude the
directed.
proceeding.
My lord,
Then what is your remedy?
they are not.
You will
considered.
file application there in the disposed writ or in press writ petition.
That was disposed of.
So you will file a petition in the disposed writ by bringing this objection for modification of order, or you will file a fresh writ petition.
I will modify the. I
So
will
you
file
withdraw this and file. If there is inconvenience, you for your submission, suit is pending.
My lord,
If the demarcation is undertaken, then there may be some complications.
my lord,
So you have a genuine case, there is no
my
issue.
lord, my lord.
But question is where to take this step.
My lord, since this
Now
is-
you apprehend that if you file objection there, he may not consider because High Court order is already there.
they may not, they
Petitioner
not accept.
permitted to withdraw this application with liberty, however, to bring application for modification or clarification of the order in WPC 13799 of 21.
My lord,
All right.
Problem.
Item 15.
Mr. Swai,
My lord,
कौन covered?
cover my lord. ସେଟା
Nischint,
ହେଇଥିଲା 10 ତାରିଖ
କପି ଦେଇଛନ୍ତି?
ହଁ କପି ଅଲରେଡି ମୁଁ ଦେଇ ଦେଇଛି ମୋ ପାଖରେ ରିସିପ୍ଟ ବି ଅଛି
All right.
ସବୁ ଦେଇଛି।
ଆପଣ ଏ କେସ୍ କଲେ ମୁଁ 5,000 ଟଙ୍କା କଷ୍ଟ କରିବି।
ଆରେ ସେ କଣ ହେଇଛି
ନାଇଁ maybe there is suppression of the fact
Suppre-
that there is a
My lord,
pending of suit.
the opposite party
He is a
number,
party to the suit.
yes, my lord.
So there is suppression of fact maybe.
Suppression,
So
I have
please
mentioned.
wait, file application there immediately.
Okay,
That will come in orders.
my lord.
Item 16.
My lord, please. But in this case, my lord, it's a second round litigation before my lord's, my lord. The case is that the opposite party number 4, even though she has,
Just 1 minute, Mr. Roy,
my lord,
you challenge annexure 6,
my lord,
where is certified copy? Where is certified copy of impugned order?
sorry, my lord, certificate copy
ଅଛି କି ଆପଣ ଫାଇଲ ରେ?
ଅଛି।
ଦିଅନ୍ତୁ। ଆପଣମାନେ କାହିଁ ସାର୍ଟିଫାଇଡ କପି ଟା ରଖି ଦଉଛନ୍ତି? କମ୍ପ୍ୟୁଟର ଫାଇଲ ହେଲେ ଇଟ୍ ଇଜ obvious କାରଣ ଆସିପାରିବନି ତା ଦେହରେ original. Certified copy of annexure 6 filed herein be kept on record. Now private party is there.
My lord,
So take notice.
oblige.
So notice on the question of admission, notice accordingly. Be kept on record.
Copy.
Requisites as undertaken to be filed by tomorrow.
Yeah.
By tomorrow. Yes. Matter be placed immediately after appearance of OP number 4.
Oblige. Register post 230.
କଣ ହେଲା?
Register post 230.
ହଁ
Register post 230.
ଆମର ନାଇଁ ଆମର ହେଇଗଲାଣି amendment କରିଦେଇଛୁ ହାଇକୋର୍ଟ rules. It is only speed post with AD.
Speed post.
ହଁ
But Xerox copy ନାହିଁ ସେ କପିଟା ନେଇଥାନ୍ତି। ମୋର ଆଉ କପି ନାହିଁ Xerox କପି ବି ନାହିଁ ମୋ ପାଖରେ ସେ ଅର୍ଡରରେ ସେ କପିଟା ମୁଁ
ଆମେ କଣ କରିବୁ? ତାହେଲେ ଆଉ ଦିନେ ଆସୁ କରିଦବା।
ନା 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 ମୁଁ ସେ Xerox କପିଟା ନେଇଥାନ୍ତି ଫାଇଲରେ ଯୋଉଟା ଅଛି
ତାଙ୍କୁ ଜେରକ୍ସ କରି ହ୍ୟାଣ୍ଡ ଓଭର କରିଦିଅ ହେଲା। ସେଟା ଗୋଟେ ଜେରକ୍ସ ଟା କାଢି ଦିଅ ସେଟାକୁ ଲଗେଇ ଦିଅ ସେଠି। Right, you will get. Please wait for some time.
Oblige.
Certified copy ଲଗେଇ ଦିଅ ସେ ଜାଗାରେ ଜେରକ୍ସ କପି ତାଙ୍କୁ ଦେଇ ଦିଅ। Yes, now 17.
Item 17.
Please, your lordship, I am appearing through virtual court Kalahandi.
Yes, long after. I have
Yes,
not
yes,
seen you for last 7-8 days. Yes,
Your
what is
lordship,
this case?
This is regarding administrative delay in sanctioning the bill to the petitioners for the installation of Minimax street
Any
light in
decision on annexure 4?
Annexure 4 is pending, your lordship.
Pending before opposite party? Who is the best person to consider?
Secretary work Panchayat Raj and Drinking Water Department.
Pass. OP number?
OP number 1, your lordship.
Okay, all right. Prayer code kar diyo. Considering on the self-same issue, application of the petitioner by annexure 4 is pending with OP number 4.
1, your lordship.
1, OP number 1. This court in disposal of the writ application, direct OP number 1 if necessary in consultation with other competent authorities, give a lawful disposal to the application involved herein at least within a period of 1.5 months from the date of communication of order along with copy of the writ application by the petitioner. Free copy of order. Yes.
Much obliged, your lordship.
Pardon?
Item 18.
May I please your lordship, my lord. I have filed an application for correction of the cell deed, my lord.
Pardon?
Correction of the cell deed, my lord. My caste, actually, I belong to SC, my lord, but wrongfully I stated to be ST, my lord.
Correction of registered cell deed
Yeah.
and a writ of pandamus. You can file an amended cell deed.
I filed a representation before the.
Representation cannot work. Sorry. That fees lagibo. Sorry. Yes, withdraw. Person wants to withdraw to attempt appropriately for the requirement involved herein. With this, requisition is permitted to be withdrawn, however, with liberty.
Obliged.
Item 19.
19, may I please the lordship, my lord, the election petitioner, my lord, filed two election miss petition.
You are return candidate or election petitioner?
Return.
Unsuccessful candidate.
No,
Not
I am
la, what is
successful.
the issue here?
My lord, your lordship kindly see the order, my lord, dated 11/5/2023. That
Order
is under
date?
11/5.
Yes,
Under
what is
Annexure
this
4 series.
application? What is this application?
The one application, my lord, under section 35, 37 and 35(3) of the Odisha Gram Panchayat Act, read with section 16, rule 6 and 7 of the CPC, and another is 38. 35(8) of the Odisha Gram Panchayat Act.
What is the application allowed? Time petition has been allowed.
No, my lord, time petition allowed to file the counter, but thereafter, my lord, rejected, my lord, on 17 and posted the case to 18. On that day, both the application allowed without giving me opportunity to file my counter.
It is allowing all these applications
lord.
or only?
Two applications are allowed.
Where do you find he is allowing the other applications?
My lord, it is reflected in the letter order. Your lordship kindly see 67. My lord.
Letter order?
Yes, my lord, that there. Had heard both the sides at length, considering the fact and order cannot be passed only on the basis of xerox copy of document. So on so this under section so on so.
Just 1 minute. Go page re poduchandi.
Lord, that is page number. Your lordship 35. And you see that.
Page 34.
My lord, 34 and 35. To call for my lord 4 official lords. The case record is put up again for hearing on the application filed by petitioner.
These were applications by the return candidate.
By the election petitioner, my lord, who lost the election.
So you are return candidate.
My lord.
These documents are available.
My lord, that document are not available with him, my lord. But he is, my lord, seeking.
Pleading was taken.
My lord. No, not pleading taken, my lord.
So where is his
your lordship kindly
where is his election petition? Let us see whether this.
Yes, my lord. Page 10, my lord, your lordship.
Okay, you get prepared. I will also look to the petition involved.
My lord, the petition, my lord.
Along with the pleading, if any.
My lord.
If pleading is there is no difficulty in calling.
Yes, my lord. Your lordship kindly see the pleading, my lord.
Get prepare yourself. I will take this matter after recess.
My.
Mr. SAHOO, could you understood the issue?
Yes, yes.
There is an application for calling for certain records.
Right.
So if it is allowed, then there must be pleading available.
Yes.
Okay. Otherwise, the evidence goes futile.
Yes. The next matter, your lordship, covered matter, your lordship. Next item.
After recess, kariba.
Item 2, your lordship dismiss for non-prosecution.
कौन करिया?
मैं क्या आसी पहुंचे लोग 5
और डाकियो रिसेस पर
आगे
मु भाबिले आपन इंटरेस्ट नहीं बोली
नहीं मु मैं थिली 4 नंबर कोर्ट
अन्य कोर्ट रे चले आपन एसोसिएट के ना दी
ना एगा आज के ना दी Orissa Real Estate Appellate Tribunal at Annexure 8 at page 163, your lordship, wherein the order imposing interest on the part of default of the opposite party has been waived out, my lord. If your lordship peruse para 163, the order of the Orissa is quoted here. Thereafter, some fabricated documents submitted in the appeal for the
No,
first time.
162.
Page
Or
163, your lordship. The order of 163, my lord.
63.
Yes, your lordship.
Where is the order of Orissa quoted? Okay,
Second,
yes.
again,
While disposing of the complaint case, learned authority passed the order.
yes, your lordship. The case
What
of
is
the
the-
complainant is
Please read
allowed.
that.
The case of the complainant is allowed on contest against the respondent without cost. The respondent are directed.
You are the complainant.
Yes, your lordship. One, Roman 1, to hand over the possession of the flat to the complainant within a period of 2 months on receiving of the balance interest amount of rupees 1,58,612 20 paisa. Roman 2, to pay interest at the rate 9.7% per annum compound
Okay, all
quarterly
right,
and
these are the direction. Now an appeal was filed by
the BDA, my lord. BDA appeal was filed. This Roman 2 of para 1.
Who was this respondent?
Respondent is BDA, my lord.
No, there the respondent, BDA
Yes,
was
your
the
lord.
respondent.
In appeal.
No, in the original proceeding.
In the original proceeding, I was the complainant and BDA is the respondent, my lord.
It is a house allotted by BDA.
My lord.
Okay, all right.
Appeal preferred by
What
BDA.
happened in the appeal?
The Roman 2, the interest part has been waived out, my lord, basing upon some documents which were filed in the appeal for the first time. That has not been submitted at the before the regulatory authority.
Whether there is pleading on the same in the
No, my lord. No, my lord.
No pleading, only material taken outside the pleading.
Yes, your lordship.
And for the first time coming to the notice of the appellate
tribunal, my lord.
Had issued notice on the question of admission to examine as to whether the appellate authority involved herein is justified in taking into account documents completely outside pleading of the respondent therein,
Annexure 4 to 11,
as well as documents for the first time coming to the notice of the appellate authority in absence of any opportunity to the present petitioner. His refugees as undertaken by Friday, considering Sri Mahapatra, Dayanand Mahapatra usually appears for the development authority, copy the OP number. Who are the parties here, opposite parties?
Bhubaneswar Development Authority and Allotment Officer.
You may have copy.
My lord.
Counter if any be filed within 2 weeks of the receipt of copy. Matter may be placed 4 weeks after. Date kar do.
Deeply obliged, George.
Mr. Mishra, appeal is confined to only waiver of interest.
Yes, Lord.
Directed to be paid in favor of the petitioner, directed to be paid by the original authority.
Deeply obliged.
Yes, next.
Item 19.
Yes, somebody was asking.
Item 19, I have verified, your lordship, kindly see page 19. There is the schedule, my lord, in the petition. In the first schedule 1, my lord, 3, 4 are in the pleading.
First come to the documents required for through
My
these application. Where is the applications?
The application, my lord, page 16.
16.
My lord. They are given 4 schedule, my lord. Schedule page
Prayer,
19.
what are the documents you wanted?
My lord, in notification, a list of candidate, objection filed by the petitioner.
No, that is
available.
page 18.
My lord. Page 18, my lord, that
And
is
schedule
given.
B karchandi.
My lord, schedule B. Schedule B document गुड़िका देई नाहंती
Schedule B documents were not there.
ना Schedule C अच्छी D भी
So
अच्छी
Schedule B document, whether pleadings were there or not.
no pleading also not there my lord.
So let us see where is the pleading. Pleading means election petition.
Paragraph 9 is the election petition so far as schedule C is concerned. Paragraph 9 and paragraph 8 is my lord. That is my lord schedule so far as the RTI application my lord that is
Issue notice on the question of admission, fixing short written intent. And the requisites as undertaken by tomorrow. Considering this is a election petition, matter is directed to be listed immediately after appearance of the private opposite party hearing. In this case, notice as above one said. Pending final outcome in the writ application. Election petition 3 of 22 may proceed, but there will be no closure of the evidence without leave of the court. Yeah.
Item 20.
This is a matter covered, you are claiming.
Yes, my lord. This is covered, cancellation of
The development authority, where is the council?
Your lordship order.
No, where is the council for development authority?
Mr. Mahapatra.
Have you been served?
No, my lord, I have not served.
I'll diyo to taako. Copy taano.
I'll serve the copy, my lord.
Lalit Mishra counsel appearing for the petitioner claims coverage of the case. Oh, এটা notice issue ହେଇଛି. Similar matter notice has been.
Notice issue ହେଇଛି.
Then I am issuing notice.
My lord.
On next date, my lord, name may be reflected.
Same order kar diyo. 2 extra copies be served on.
My lord,
who will be filing counter affidavit at least 2 weeks of service of the copy.
My lord, name may be reflected on the next date.
On the next listing, name of Sri Mahapatra be indicated as the Council for Development Authority. Same order over.
Obliged.
Item 21.
Consolidation revision.
Press admission.
Press.
All these matters. Press admission. 1 week. Yes.
Item 22.
To my lord, I permit to withdraw lordship, permit to file the petition before the RDC court of lordship.
All right, petitioner wants to withdraw the writ application with in order to approach the competent authority. Withdrawn, however, with liberty as per for.
Item 23.
My lord, the petitioner challenges the order passed by the NCLT. My lord, what it happens, my lord, we had filed an application for joint inspection and for valuation. My lord, page 316, lordship kindly see. And they had filed an application for taking over position. So without he passed order on taking over position, but did not pass my petition on my IA. Because this joint verification valuation is a must before taking over position. My lord, page 316, lordship kindly see.
No, there is no appeal lies to NCLT.
My lord, NCLT appeal, but that is the judgment in this case, my lord, NCLT appeal, it will take at least more, it is taking a month, more than a month to get the matter listed under the
issue. But how can we avoid a statute?
That is the judgment of the Supreme Court also, that your lordship can interfere. I have got the judgment. I have got the judgment. It is maintainable that I have got that judgment. It is maintainable because, you know. So the procedure violation in case of
Annexure 7.
Annexure 7, that is page 357, is the order. Impugned order.
357.
Impugned order. My lord, may kindly see.
Next page. This
Where is the certified copy?
certificate copy nahi? Oh, that is the copy they are giving, my lord.
No. This is Xerox copy of the copy communicated.
Copy.
This is
नहीं,
not
certificate copy
a-
दो ना NCLT से appear करते regular जाओ से certificate copy दो ना यही copy शांत हो
No, no,
सकता
ठीक है, communicated copy तो.
communicated copy.
Communicated copy is also acceptable. There is
Huh.
no issue, but this never be a communicated copy. This is just a Xerox copy. Your counsel is.
upload এটা uploaded copy তাঙ্গর uploaded copy এটা uploaded বা signature ଅଛି ନା ତା website uploaded copy ତାঙ্ଗ ସେଟା website uploaded copy certified copy my blunt friend is regularly doing all
They
this
must be giving certified copy.
no
It's a judicial proceeding, maybe under statute.
But they are not given. My learned friend is regularly going to NCLT and in from doing page 358. My lord, in respect of prayer B pertaining to documents of this application, respondent directed to furnish list of documents so far delivered and reason for not first one. Section 25(2) of the IBC code in the stated scenario, learned RP is directed to take custody and control of the plant and machinery, all the assets of the corporate debtor. If he finds any resistance, he may approach the authority for an assistance to take possession. And then they will also kindly see IA 1B number 177, which I had filed. Lord Counsel, Mr. SKHR, appearing for RP, states that the copy of the application has not been received. Lord Respondent Counsel directed to serve by email today itself. Respondent is given 2 weeks time to file their counter and copy the list. So, my lord, so it was adjourned and this application was allowed. And that is a necessary thing because unless I am ready to.
You are agreed by Annexure 7?
Annexure 7.
Annexure 7, what is the
They directed for the taking over possession, first para.
No, where do you find that?
In the instant case, my lord, the first top rate. 358, page 358.
Page 358.
My lord.
You just read that.
In the stated scenario, the learned RP is directed to take custody and control of the plant and premises, all the assets of the corporate debtor. If he finds any resistance, he may approach this authority for any assistance to take possession in coercive manner with police help.
You are a party there?
Sorry, my lord.
You are a party there?
Yes, I am a party there. I am a party there. That is the reason why I have also filed an application that I do not have an objection to take over possession because I cannot. Only thing that before taking possession, you will have to joint inspection, valuation has to be done. Unless valuation in joint inspection, joint inventory, valuation is not done. How you can take possession after taking possession?
That's the only resistance.
So that is the reason.
There should be inventory
right.
Of the property taken over.
Right.
All right,
For which I had filed the IA.
Who is the contesting party here?
Contesting party, the opposite party now the bank, I think. Opposite party number 2.
OP2.
The Canara Bank.
Who has been directed to take RP means?
RP means the opposite party number 3. The resolution professional, son Conti. The one official liquidator appointed, it was the resolution professional.
Okay. This read petition had the submission of Sri Misra, assisted by Sri Misra again, Manoj Misra, Tanmay Misra. Impugned order Annexure 7 appears to have been challenged only on the premises that there may not be any difficulty in taking over the custody and control of the plant and premises and the assets of the corporate debtor. However, before taking such property, there should be having inventory, at least to maintain the stock of the property.
Joint inventory.
At least to take stock of the property.
And valuation.
Okay. We issue notice on the question of admission, fixing short returnable date, made clear the matter will be disposed of at the time of press admission itself. Requisites as undertaken by tomorrow. Tribunal ko kain pakhe korchundi? Tribunal is not required to answer. Somebody is appearing probably for tribunal. Union India.
Union of India might be
okay. For the timing, notice may be issued to OP number 2
and 3.
2, 3, and 4.
Yes.
2, 3, and 4. Matter may be placed immediately after the appearance of the opposite parties 2, 3, and 4. In this case, notice as above. As an interim, it is observed in the event the order dated 26/6/23, find place annexure 7, has not been worked out as of now. Same may not be worked out without leave of the court. This court further observes in the event there is no disagreement in between the parties, possession of the property and or the working out in terms of the direction, annexure 7 may be permitted, but however in the participation of the petitioner and entering into a joint inventory in the presence of the petitioner.
And valuation also. Joint inventory and valuation also.
Joint inventory. Valuation kon sang sang hei peribo.
Valuation tankor valuation kala par sunne that is the
valuation 35 karibo. Je nabo property.
See valuation karibo. Tapare valuation hobo. Tankor achi statutory provision achi kemti valuation hobo. That is the provision. Section 35. Deeply.
But this decision, Mr. Mishra, this decision may not apply to the case. Here the case is jurisdiction attending to the.
No, khali dita point rahi period judgment. Dita point rahi period. Gote hela je but excess of jurisdiction also statutory violation hale bhi hobo. We have got statutory violation because section 35 is violated here.
Section 39 speaks for joint inventory.
Joint inventory. 35 na? 35.
Decision placed to support the case of the petitioner be kept on record.
Deeply.
Please.
Item 24.
May I please, my lord? The prayer of the petitioner to direct the opposite party number 2.
Demarcation case is still pending.
Still pending.
It's not registered.
Yes, it has been registered by 129.
Case number, what do you find?
Annexure 4. Se receipt जो देइछन्ते से receipt रच. Case number 129/23.
Case number 123, 29/23.
23.
All right, demarcation case disposal and giving opportunity to party likely to be affected, completing entire proceeding within a period of 3 months of the communication of order. Page 10 demarcation case number.
Why I filed this case? They have issued notice to the annexure 2. Can I have a glance? They have issued notice. Government has stated that I have encroached the government plot.
No, that's a different issue.
Different only.
I have no jurisdiction in
short date.
OPL matter.
3 months.
Sorry, you can't double his application.
One
One hand you are challenging the OPL order.
OPL order I am not challenging.
Then
only I want the OPL order that the among plot bhangi debe. Among 2-story building is there.
Then what is the best course? What is the
my
best
prayer
course?
to demarcate my land.
So therefore, these are two-faceted proceeding.
No, that
OPL
is
has
separate.
nothing to do with the demarcation. Demarcation is completely different issue. Maybe Tahsildar is the
only
authority
short
for
date
both purpose.
short date. After 3 months take se
Sorry,
kana
sorry.
bhangi debe se kare.
तारा appeal अच्छे appeal file करूँ stay नेबे. Yes, next.
Item 25.
First contempt.
Second contempt.
My lord,
Second contempt.
on behalf of
What are the direction there?
My lord, on behalf of Mr. Manas Ranjan Naik, this is the second contempt.
Direction was
Hard
dated
contempt.
4/1/2023.
What are the redirection?
Redirection to consider his application within 7 days.
That also not being done in spite of a second contempt. Also personal appearance को.
ना इटा second contempt रे file करचंती. First contempt रे order ता हितले 3 दिन भीतर कर दे बोला पे.
से भी हेला नहीं.
सेटा ही need second contempt.
So you are compelling party to come to court
Yes,
unnecessarily.
ताको ऊपर notice जाओ.
अच्छा notice.
Contempt notice जाओ.
This is in second round of contempt on a simple direction required to be complied in the disposal of the read petition WPC number Yes, what do you find the read petition note? 36400 of 22. Yes. And even after, this is the stage continuing even after. Disposal of first contempt, right? Contempt case number so and so. This court finds there is serious negligence by the contemptor. Direct personal appearance of the contemptor on the date of posting on 25th of July. Requisites as undertaken by tomorrow. Tendency of the contempt, however, shall not stand on way in working out of the direction in WPC 36400 of 22. Order dated 4/1/23 in WPC number so and so. In the meantime, copy what they do. You have a copy on him so that he can send instruction. So next date it may be infructuous. You may get an outcome.
Item 26.
But here, though it's a first contempt, last occasion the state council said that on third we are complying your lordship's order.
Madam, receive korichi. I will be filing an affidavit.
You file an affidavit. All right. Contemptor appearing through Sri Ghosh seeks time to file counter affidavit to objection to the contempt application.
Like affidavit, compliance affidavit, जहाँ भी affidavit file.
कितने दिन file करिए?
10 दिन time दो, 10 days.
Objection be filed, brought on record within 10 days with service of copy on the other side. Matter be placed 3 weeks after the response to objection, if any, we also brought in the meantime. Give a date after 3 weeks.
Item 27.
My lord, your lordship may kindly turn to page 9. In spite of your lordship's clear direction at paragraph 8, they have not disposed of my mutation case. My lord, there is
Page 9.
Your lordship may kindly have a look to the judgment of this Karnataka High Court, where they imposed cost of rupees 3 lakhs for non-compliance of the orders passed by the Karnataka High Court.
Karnataka is a rich state.
No, 3 lakhs mu kahuni. Your lordship may kindly see. This is the conduct of the
You
state.
know, MLAs there are kept in hotel for months together.
Say situation ta iti hai nahi to.
Such a rich state.
My lord, your lordship may kindly have a glance to that judgment.
All right, let us see an outcome.
First.
Direction to the
Your lordship may
It
kindly
shall succeed, but with an order of remand.
Yes.
Of the mutation case.
Yes.
When this order was passed?
My lord, your lordship passed this order on 31/1/2023. 2023.
Okay, when this copy was served.
My lord, copy was served personally to the, I have made the
Suppose it is better, let us give them 1 month more time.
Yes.
15 days.
If I issue notice, it may be delayed by 3 months.
My lord, I am just praying your lordship may say 15 days. Can you say Tahsildar is on the
15 days may not be
transfer of a virgin, say may say God chalchi je mu transfer he ju mu karibini. And otherwise reason my lord I cannot
ଭଲ
say.
ତ କାହିଁକି ଆପଣ ତା ହାତରେ ଅର୍ଡର ଟା ନବାକୁ ଚାହୁଁଛନ୍ତି?
Yes.
ସେ ଦେଖନ୍ତୁ ରିଜିଡ୍ ହେଇ ଅଛି ବେଟର ସେ ପଳେଇ ଯାଉ ଆଉ ଯିଏ ଆସିବ ସେ କରିବ
କାହିଁକି appointment ନ ହବ ମାସେ ଦିଅନ୍ତୁ.
ହଁ ମାସେ କୁହାଯାଉ ଦେଖିବ
But your lordship may kindly note my contention that judgment.
ଏଠି ବି ଆମେ ବେଳେ ବେଳେ କହୁଥିଲୁ ନା ଇଲେକ୍ସନ ପିଟିସନ ଅଲରେଡି ଦେଖିବା କିଏ ଷ୍ଟେ ଭେକେଟ୍ କରିବ will allow the read petition to become infructuous. हजार read petition ଗ୍ରାମ ପଞ୍ଚାୟତ ସମିତି infructuous କରିଦିଆଗଲା
ହେଇଛି.
So
ଖାଲି ଗୋଟେ ଜିନିଷ
don't rub your shoulder there.
My lord, I'll just pray one thing.
Contempt, 1 month time.
Your lordship may kindly note that judgment for my client's convenience.
ରଖନ୍ତୁ reserve it. Second contempt ଆସୁ ତାପରେ ଦେଖିବ କିନ୍ତୁ ଆମେ 10 lakhs କରିଦେବାରେ କିଛି ଅସୁବିଧା ନାହିଁ contempt appeal ଯିବ ସାଙ୍ଗେ ସାଙ୍ଗେ ମାନେ ବସିଛନ୍ତି ତାକୁ appeal entertain କରିକି ତାକୁ 10 ଟଙ୍କା କରିଦେବେ କଣ ଲାଭ
ଟଙ୍କାଟେ ହେଲେ ବି ଆଜ୍ଞା ଫାଇନ୍ ତ. My lord, it's a punishment. Even if it is 1 rupee.
Punishment. If it is a punishment, there is no difference between rupees 1 or 1 lakh.
1 lakh.
So therefore, why 10 lakhs?
My lord, what the Karnataka High Court said, not only he deposited 8 lakhs.
ଆମେ 10 lakhs କରିବୁ ମାନେ we compel the party to go higher up.
Yes.
Which party will be sitting down with 10 lakhs cost?
And not only that, my
ଏ
lord,
ଭିତରେ ଆପଣଙ୍କର ସେ 10 lakh ର cost କୁ defend କରିବା ପାଇଁ ଆପଣଙ୍କର ଆଉ କିଛି ପଇସା ବର୍ବାଦ ହେଇସାରିଥିବ As on the next case.
For orders item 28.
এটা appearance করিব।
May I please, your lordships?
Appearance of senior advocate Sri Sanjit Mahanti and Sri Jankalyan Das, senior counsel, accepted and be kept on record. Yes, who is for petitioner? You are there for the
I am
petitioner.
appearing for the petition.
Please be on mic.
I'm
Okay,
sorry.
now we have a different
Oh,
setup.
I am sorry, my lord. I am appearing for the petitioner in the review application,
Right.
my lord. The review is
Review
filed.
order, let us see what was the High Court direction.
Your lordship, not High Court direction. High Court has allowed the revision CMP
Right,
and dismissed the suit which is pending before the trial court.
right.
Because actually I filed a civil suit for an injunction restraining the respondent 2 to 10 from attending the office of the first defendant company and as a director of the first defendant company. The respondent 2 to 10 has not, though appeared, not filed anything. First respondent filed an application under section order 7 rule 11 and for res judicata, and also another application under section 11 read with 151 for abuse of process of law. Both applications was heard by the learned judge. A combined order has been passed in both applications were dismissed. Against the dismissal, my friend has filed an appeal, CMP. Here it's called CMP under Article 227. Your lordships very well know about it. If an application has been filed, section 115 is there. The question of fact and other things. When section 115, the remedy is available under 115. The question of filing an appeal under 227 does not, filing a writ under 227 under supervisory power does not lie.
Where is the scope of appeal?
Not appeal. CMP
115
under
revision.
revision 227 and revision. They are filing it.
No, 115.
115, they have to file a revision
Say
before the
115 comes into play.
yeah, from the the district court.
That's right. There is no dispute in that. But question is,
yes, my lord.
question is the miscellaneous applications were allowed or rejected.
Please correct me, lord. Miscellaneous
No, miscellaneous cases were rejected or allowed.
is rejected.
So order 7 rule 11 rejected.
Order 7 rule 11 rejected.
Rejected.
Only revision. As per 43.
No, but this court entered into further facts that in fact there was no dispute surviving.
No, my lord, that will become later. That will be at the time of file.
Then
your lordship, I will
probably, if I remember,
yes, my lord.
Nobody appeared for you.
Yes, myself. I'm sorry, my lord.
Yes.
I'm sorry, my lord. I'm very extremely sorry. Earlier to that, there are number of occasions I myself came and argued, matter was fully heard by your learned predecessor judge. But subsequently, then it was from the part where it was de-linked and I will not hear anything about it. In the meanwhile, there was a change of counsel on my side, but the previous counsel name was shown in the cost list and also my name. I cannot say about any other things. Therefore, my counsel has not seen it by mistake. He has not looked into and he has not informed it. And it was ordered by your lordship. Orders has been passed. Against the said order, we went to SLP. SLP, they say you can file a review. Therefore, we may say we will come over it.
You have gone to Supreme Court.
Yeah, yes, my lord. Yes, against that order.
Supreme Court, you have taken there that I will be withdrawing this
1 minute, sir.
to move a review application.
1 minute, sir.
Now Supreme Court, without expressing anything,
you file a review application.
Liberty has been given as is wrongly projecting.
No, liberty has not been given, but strange order is there. Now recently Supreme Court itself referred a matter to the Supreme Court, to the larger bench, saying once a review is entertained in withdrawal of a SLP,
yes,
whether further SLP will be entertained or not. That's the point of reference to the larger bench. Read that Supreme Court order, what the Supreme Court has done. Again, granted, permitted, if you lose there, then it is open to you to bring.
That's a settled position in law, my lord.
Contradicting their
I
own
don't know.
order.
But in the fact.
Now the other issue is,
Yeah.
Mr. Mahanti, Senior Mahanti, both of you are for same party. Okay, now that he has come back from the Supreme Court with a rider to have a review application is already filed. So why don't you file your objection?
For what?
At least put up your objections there.
No, why I'm saying, kindly see my friend is.
The question is, Mr. Mahanti, kindly bear in mind, Supreme Court has said, any adverse order is passed, it is open to entertain a SLP. So therefore, SLP is undisputedly coming again.
No, Milord, your
So
lordship.
therefore, I want to know your views in your written statement, in your counter, so that I will give a reason order.
Milord, what I beg to say, Milord, there are two applications before the learned civil judge. One is 151. Other one is Order 7, Rule 11. And this, Milord, the CMP, which, Milord, the both were allowed. He has filed SLP against the Section 151 order. Section 151 order was abuse of the process. Then SLP was filed against only one order.
Only 115?
Yes, 151.
Give the SLP copy.
And, kindly see, the second SLP he has not filed. Then, Milord, then he has taken, what has done, the court has stated here, Milord, in the SLP order.
But
Arranging order.
Final judgment and order dated 10/3/22.
No,
yes.
10/3/22 in CMP number 861 of 2016.
Only one.
Was that day?
That is 151.
Two CMPs.
Yes, there are two CMPs.
Yes.
So it is only 861.
Yes.
Let us see what is the order in 861.
861, Milord, your lordship kindly see.
In the review itself, we are enclosed in the annexer number 11, my lord. Annexer 1.
Yes, Milord.
Page number 11.
Just 1 minute.
It starts from annexer
Both the councils.
Yes.
Please, just 1 minute. You please bring, let him bring the SLP copy. And you also provide the CMP petition. Because
CMP
it's very
petition
bulky
is
now.
there. I'll give.
So I am taking it day after tomorrow.
Next week, Lord, I have to go.
Difficulty. Tell when we will apply.
Next Wednesday, my lord. Tonight I'm leaving.
Next Wednesday?
Next Wednesday.
No,
Next Wednesday?
19th.
Let it know 19th.
So let that be, 19th he says.
Yes.
Next 19th, next Wednesday. 19th only I'm absent.
On consent of parties, matter is fixed to 19th. The parties are also directed to provide the copy of SLP.
No, your lordship, not party, your lordship states that the review petitioner should, because I don't have SLP.
Okay, review petitioner is directed to.
I have produced it. Your
Provide the copy of SLP.
Yes.
19262 of 22. It will contain all copies. Mr.
Yes.
Mahanti, don't worry.
Yes.
It will contain all copies.
Yes.
Only thing is, you may provide the other CMP order.
Yes, I'll other CMP order, and also, Milord, why I'm saying.
I understood. You say there are two orders.
Two orders.
So 711 once not challenged.
Not challenged.
It is
became final.
automatic.
No, it has become final.
It is automatic.
Yes.
I understand.
So that is already there.
I understand.
Your lordship,
And your
may
lordship can
I say one thing?
No, today no further.
No argument, just for things
Please
your
keep
lordship.
it reserved. Please
Yes,
keep
my
it reserved. We
Yes,
will
ma'am.
argue on that day.
Yes, yes,
I am not closing my mind.
Yes, my lord.
I didn't part with it. Matter to be placed on the 19th again.
Lordship, at 2:15 at same date, 19th, 2 o'clock after lunch.
No. Let it be there in the list. No time fixed.
In same position.
Milord,
Yes, my
whatever, Milord, see, we are waiting because we are eager to take up the matter. If a time fixed, that may be difficult.
No, time cannot be fixed.
Yes,
I don't
my lord,
fix
yes,
any
my lord.
time.
Yes.
I am reaching, maybe.
It may reach before lunch. Why
Ah,
fix it at 2:15? He is asking that it should be fixed at 2:15.
Arre, we-
Glad. what I am thinking about it, definitely if it is to be in the
I'll
length,
take up
it
the
can
matter
be.
that day. I'll take up the matter.
Yes, my lord, much obliged.
Item 29.
May it please your lordship, my lord. I'm on VC if your lordship kindly. Yes.
Yes.
But I filed an IA in this particular writ petition.
এটা भी सही केस रो बोलते देखिलो ये appearance भी सही केस रो what is this IA?
But this IA arises out of the writ petition, which is a double allotment
That
matter.
is already entertained.
Yes, my lord. It is a similar order has
As
been
an
passed, my lordship.
intimator, it is directed status quo as on date.
Yes, my lord. Now your lordship will see the order passed by my lords in a similar matter, but this is a double allotment matter, which your lordships have been entertaining over a period of time. And if your lordship sees annexure 1 of my IA number 6975 of 2020.
There is final order.
Yes, my lord. Your lordship has entertained a similar writ petition and a direction has come through. I just wanted your lordships to see that, my lordship. So that order is annexure 1 of the IA.
Yes.
Page 7.
Is it involving same property?
Not same property, same dispute. Double
Similar
allotment.
dispute.
Double allotment. My lord. Lordship, that is WPC number 12511 of 2022.
Yes.
Braja Mohan Rao. Your lordship will kindly see paragraph number 2.
Yes.
But considering the contention of the petitioner and the submission of Mr. Mahapatra, learned counsel for the Bhubaneswar Development Authority, and as this court finds there is foregoing of one plot by plot number so and so involving multiple allotment, this court directs that in the event the petitioner and his wife make joint effort for surrendering the plot so and so before the Secretary, Bhubaneswar Development Authority, opposite party number 3, within a period of 15 days hence, the Secretary, Bhubaneswar Development Authority shall do well in reconsidering the issue involving annexure 1 and passing an appropriate order thereon within a period 1.5 months thereafter.
You want parity.
Yes, my lord. Yes, my lord. But I've also mentioned
Have
the
you
plot.
taken instruction? Have you taken instruction? You want to surrender one?
Just before what, on C11, yesterday I received the copy of the miss case. Enumerals, my learned friend says that you wanted to surrender one plot, which will be the subsequent plot he has to surrender. First plot he has to retain this much. If he approaches for that.
So you file an affidavit showing your readiness, you are surrendering the second plot.
No, it's your lordship in the case that I have annexed to the IA. Your lordship had asked the learned counsel in the relevant case as to which plot he wants to surrender, and he had not volunteered to surrender the first plot. But here also I have mentioned in my IA on affidavit that I'm surrendering the first plot.
Surrendering second.
Fact remains what is happening. Earlier they must be taking one plot, smaller size. Subsequently must be getting another bigger size plot. That might, with that observation, my
Then you file an affidavit.
let him file that affidavit so that
you intend to surrender.
Fine.
With plot number, etc. So we can cover the case by this. Or
Yes.
I'll dispose saying that.
minors may dispose it of minors, send it to minors secretary.
File affidavit there.
In the light of this decision.
But even
so
in
that they
this
can examine
IA,
it.
even in this IA, my lords, I've mentioned the plot number. I wish to forego.
You wish to surrender. So
Yes.
it is also sworn again.
Yes, my lord.
All
So
right.
that
Where
is
do you
paragraph
find
number
that?
So it's paragraph number 5 of the IA, if your lordship kindly sees, page number 4. Your lordship will see in the middle portion of that paragraph, I have mentioned the plot number K7-519 general.
He has already indicated.
Yes.
So let him surrender that and you
Minors,
regular in the
only,
second.
only minors, my objection may be recorded that yes, two plots, subsequent plot is to be surrendered. Minors may give an option either of the plot.
Advantage should go
But
to the
so-
party.
so no problem.
ଗୋଟେ ଭଲ ବଡ plot ଟେ ଯଦି ପାଇଛି,
All are not. He is retaining one plot and
one is not allowed.
it is greatness because he is going to surrender and complying the order.
No. Here, you can take advantage of these two orders.
Yes,
The
ma'am.
order Annex here and the order now I will be passing in return.
Yes, minors.
Sir,
I have done it.
multiple plots, see, this is the.
I have done it there, minors.
Yeah.
Already I referred to one and now I will be referring another one.
So you are winning here.
Yes.
At the submission of respective council, so long. Matters the notice being convinced with the undertaking of the petitioner that he is ready to and willing to surrender one of the plot, particularly plot number para 4 na?
Five.
Para 5.
Para
Case
5,
7,
sorry.
519.
plot number K7 519. Bracket general measuring 2400 square feet under Kalinga Nagar plotted development scheme 1991. This court was inclined to issue notice to find a block to the impugned action of the development authority. There has been consequent upon service of notice, there has been. You have filed counter?
No, no, I have not filed.
The appearance of the development authority. In the pendency of the writ application, there has been filing of IA 6975 of 53, bringing into the notice of this court a decision in similar situation and thereby accepting the request of the petitioner therein in the surrender of one of the plot to retain the second plot, he retain the other plot. Having been allowed in the order dated 18/5/22 in WPC 12511 of 22. The Misral and a counsel of petitioner appear herein in the light of aforesaid direction claims, while claiming parity to the case at hand, brings to the notice of the court the clear statement of the petitioner through para 5 and submits the petitioner herein is ready and willing to forego plot number K7-519 bracket general measuring 2400 square feet under Kalinga Nagar plotted development scheme 1991. Sri Dayanand Mahapatra, however, in his objection to the request of the petitioner submits, there may be a plot intending to surrender less advantageous
Subsequent one.
than the more advantageous than the less ho na jota surrender karuchunti less ho. Less advantageous to the plot sought to be retained by the petitioner. Considering the and leaving the matter for decision of a lawful decision of the court.
May I submit my notes? My humble contention is that suppose he has been allotted 2 plots, he has to retain the earlier one to surrender the subsequent one. That is what my.
Where do you find that?
Usually, my lord, the second plot is.
Submit.
I'm submitting the subsequent.
Sri Mahapatra further submits in natural course. Second plot.
This is
required
illegal.
To be surrendered.
This is the illegal.
In the retention of the first plot. And leaving the matter for a lawful decision of this court. Considering the objection to the request of the petitioner herein, this court find undisputedly petitioner is in possession of 2 plots. One bearing case 7-519.
May I just
2400 square feet.
I'm so
on
sorry.
the Kalinga Nagar plotted development scheme 191. The other one being.
I just feel like to interrupt your lordship. I'm so sorry. But my lord, in throughout case in the writ petition is, I am not in possession of the earlier plot. I had written a letter surrendering the plot as back as 1999. That was my specific stand in the writ petition.
Why do you want adopting this judgment?
Now, because my lord, that surrendering has not been accepted.
Not being accepted if it is you are pleading in the writ application.
Yes, my lord. Yes, my lord.
So in the contingency, you are in possession of 2.
Lord, that I have vacated. There's nothing on that plot. It's a vacant plot.
Minors, may I submit minors, then it may be kept. Minors, I will take instruction, may be taken up some other. Some other problem.
All right. Matter is final hearing, khali count. All right, then let us enter into hearing. For the timing, you are in enjoyment of interim order.
Interim order.
The interim order to continue. Let a counter affidavit be filed with.
You need an next week, minors.
3 weeks. ଆଉ ଏତେ କଥା ବୁଝେଇ ସାରିଲା ପରେ କହିବେ ମୋର ଆଜ୍ଞା ସେଇଟା ଦେଇଦେଇଛି ଖାଲି ପଡିଛି ହବ କି?
If that would be so, my lords, you will not be having any plot.
No, no, second plot, I am in possession, I've constructed a residential building. That is my, my lord.
Mr. Mishra, ଆଉ heavy case କିଛି ମୁଁ ନେଇପାରିବିନି ଆଜି।
No, no, heavy case, no matter what formal orders.
My lords, I have got the instruction.
Only one.
ଆପଣ ସେଦିନ
Kindly, Lordship, kindly.
Sir, I am supposing you.
Modification of a condition only.
reduction
Sir,
କରିବା
I have got it.
Action, my lord, what I am saying that your lordship had passed that order, continue the basing on the submission that investigation pending. So investigation is complete now. After investigation is complete. After investigation is complete, there is no further. I do not want any other. I will keep them.
the outcome in the
My lords,
investigation.
Sir, but what is the necessity of this?
What is the outcome in the investigation? Is anything adverse? Fine.
No, my lords.
Oh, they have imposed fine and we
Yes,
have,
yes, my lord.
we have
But
made,
so far as the
after
lordship-
completion of investigation, they have computed the fine and we have preferred appeal. And there is no further investigation is
So
made.
then it has come back to square one position.
No, my lord.
You have challenged.
No,
My
my
lords,
lord,
my lords, in the last occasion,
my lord, penalty, that is the penalty about the investigation. Lordship will remember that I had argued that lookout corner notice. Lookout corner notice cannot be issued if there is no criminal offence. And your lordship has referred to all the judgments of the state, and the lordship judgment is the first judgment of the Odisha High Court. First judgment of the Odisha High Court. So what is that? So in that case, there is absolutely no criminal case, no criminal offence, nothing of the sort. If there is no criminal offence and there is no that company, the violation of some company, minor provisions of the company. Record देना थी, all these things minor. Total 15 lakh से impose करते ये which
Mishra and Mr. P.P.
Be-
Mahanti.
नहीं
Prabhu Prasad. na?
Prabhu Prasanna Behra.
Prasanna Mahanti.
बेर
Both of you just listen. Now the repetition was disposed of in the pendency of an investigation.
my lord.
In the pendency. Therefore, conditions whatever attached in the pendency of an investigation.
Right.
So that is definitely subject to an outcome.
Outcome,
Once the outcome has come,
my lord,
then
that
the
is,
conditions goes automatically. I am
Oh.
passing that order.
yes, my lord, that one.
Conditions goes. Mr. Mahanti, what is your answer?
My lords, that
Condition automatically goes.
in the last,
Now suppose they want to fly,
my lords,
you want to block,
yes,
then the further proceeding is before
No.
the authority pending.
my
No,
lords,
there is
that
no,
I, that
nothing
I,
is pending for any authority.
Further.
Absolutely.
Nothing is pending for any authority.
Right.
my lords,
Right, I
last
understood.
occasion, your lordship has directed me.
Therefore, I am clarifying.
My lords,
No, actually, no reduction is necessary.
my lords,
No relaxation is necessary.
my lords,
Because once the proceeding is concluded
my lords,
and landed in another proceeding pending somewhere
Yes,
else,
yes.
then conditions whatever has become infructuous.
My lord, that is true.
Mind ଆସୁନାହିଁ ଶୁଣିଦେଲେ ହେଇଯିବ।
And my lords, one more submission.
ଇଏରେ ଅଛି ମାନେ ମୋ staff shortage. Otherwise also I am occupied somewhere else. Therefore, okay, all right, I am passing the order.
My lords,
Had the submission of respective councils.
well, in the last, only for reduction, your lordship had taken.
Oh,
directed
that
me
your
to
lordship,
take
your
cons-
lordship.
take
Pardon?
ins- Only for the reduction, your lordship had
No,
directed.
reduction is not
Okay.
necessary. I will
My lord,
clarify.
yes.
That,
Yes.
that order
My-
has lost its force.
Yes, my lord. Lordship has clarified that.
Not had it
Therefore,
actually.
therefore the, and order if any there has
Yes.
become innocuous.
No, my lord, the only submission, lordship may kindly
Mr.
record.
Mahanti, admittedly, there is already further proceeding or not.
Yes, ma'am.
Investigation is complete.
Therefore, and the undisputedly, the read petition was passed,
Yes,
disposed of pendency of the proceeding.
There's only one submission, lordship may record that the instruction is, there is still the flight risk is there. That may my
Yeah,
submission.
right, what?
There are still,
The flight risk, which I had argued on the, in the main case, my lords, that apprehension is still there.
no, apprehension if there,
Yes, ma'am.
then a fresh cause of action may
My
be
lord.
there.
My lord. Well, that may be observed.
It's over. Therefore,
What
why
I humbly
have
submit, that may be observed, my lords.
Oh my goodness.
That may be observed in lordship's order.
Stands to the same.
I miscase ର ଗୋଟେ କପି ଟେ ଦିଅନ୍ତୁ ଇଏ ଗୋଟେ 8 କିଲୋ ବ୍ରିଫ କୋଉଠି ଏକା ଖୋଜିବି ସେ miscase
ନାଇଁ ସେଟା ଦଉଛି।
and a judgment copy ବି ଦିଅନ୍ତୁ ସେ judgment ର copy
Judgment captain.
judgment
Page
copy of
20
course I can
page.
find it it is here
ମୁଁ ସେଟା
judgment
fold
copy is
କରିଦେଇଛି।
here only
ଆରେ
give
ସେଟା
me the
fold-
miscase
fold କରି ଦେଇଥାନ୍ତେ ନା ଆଉ। ହଁ
only the miscase
ହଁ ଦେଇଦିଅ। କହିଲେ ସେଟା-
judgment copy is here I have got
Judgment copy ଟା ଅଛି।
ଦରକାର ନାହିଁ ନେଇଯାଅ
Last para 20.
this is a miscellaneous application It a submission of Mr. Manoj Mishra, assisted by Tanmay Mishra, PP Behra, CGC. Rajya miscellaneous application for modification of the conditions in the judgment of this court dated 25/7/22 in WPC 9502 of 22 with WPC 12872 of 22. Undisputed fact remains, and as disclosed to the interim application 7215 of 23, the investigation against the petitioners involving the writ application having been over, there has been already imposition of penalty by way of financial punishment.
Annexure 14, 1/4. I hear a 1/4.
Okay. By way of order dated 1st December 2022 by Annexure 14 to the interim application herein. Undisputedly, there has been also challenge to this order.
We have preferred appeal. Preferred appeal.
By preferring appeal pending before NCLAT.
সেটা হচ্ছে কোর্টে
এই মিস কেসরে লেখিଛନ୍ତି appeal ଅଛି ବୋଲି
লেখা আছে
before the
regional director
before
regional director, the higher authority regional director of the company, registered company,
before the regional director. OP number 1.
opposite one number 1.
For there is already there is also no dispute in the bar that the judgment dated 25/7/22 in WPC so and so was passed in the pendency of the investigation. In the circumstance, this court find whatever conditions imposed in the disposal of the writ application were all subject to the final outcome in the inquiry pending against the petitioners. For the inquiry already completed against the petitioners already completed and the matter landing off in appeal, the conditions passed in the writ applications have become innocuous and infructuous. In the circumstance, this court, while dropping the IA number so and so, observes there is no need of entering into such question even. Keeping in view the observations herein above.
Diploma. Your Lordship's order was, I was referring in a matter in Calcutta High Court. only few days back. And that is এই judgment-টা first judgment-টা মানে ওড়িশার first judgment এটা. Judgment is much better than Punjab Haryana or other High Court judges.
Allowed to operate it.
After your Lordship's order, my lords, we have also, department has also taken up the issue, and so far as the lookout corner notice, which they were not publishing it, hence my learned senior has
This is an eye opener.
Yes, my lord, absolutely.
What stage you should land?
And that is why my
You
learned
should
senior has
restrict.
faced the difficulty in annexing the impugned notice. Now they are uploading.
Probably I have taken note of so many decisions.
So
Yes,
many
madam.
decisions. Different High Court decision, Delhi High Court, Punjab Haryana
It's a
High Court.
good opportunity, good assistance.
No, but this judgment
Ultimately ended in a good judgment.
yes, this judgment actually is a better judgment than but I am not here, but it's a in fact
এইটা গোটে আর পাসপোর্ট রে গোটে মু দুইটা করে I have given everything there.
সেটা সে যে হাই কোর্ট যারা বার করছেন সেটিরে আপনি এই তিনটা জজমেন্ট আপনাদের আছে পাসপোর্ট এটা
অলরাইট আরো কেস গুড়াক ସବୁ আরো সপ্তাহে কিছু কিছু দিন ହେଇକି ଆସିବ.
Well, so far as item 38 is concerned.
কোন 30 রে কোন পুনি মডিফিকেশন 30 তো সরলা
31 টা বেল
31 রে বেল
6 ବର୍ଷ ହେଲାଣି ରହିଲାଣି 3/1/2017 નું ସେ କଷ୍ଟଡି ରହିଛି. Earlier, my lord had twice directed the trial to be expedited.
Yes, have you examined? Others have been granted bail.
Others have been granted bail, Your Lordship. The allegations against this present petitioner is that he was the one, in fact, who has shot the victim on the head, Your Lordship.
Similarly standing or not?
Lordship, I'll have to examine the entire case diary, which is not with me today. Lordship, may call it next week, Your Lordship. Because that is the only difference. All of them were there.
Wait for some days.
My lord.
Next Wednesday.
My lord.
On the request of State Council who wants to have further reading through the case diary to find whether the petitioner herein stands in same footing to that petitioners already under bail orders. Yes, 31 jay gola. Ye review petition kono dispensing with filing certified copy.
May I please? I am
32 re kiye dispensing apply korchandi.
I am for the review petitioner.
32 kiye who is their counsel? Yes, sir. Yeah, how can the order sought to be reviewed be dispensed?
Your Lordship, ma'am.
Pardon?
I am through VC, my lord. I am appearing in this case for the petition.
Through VC doesn't mean you are exempted from argument.
No. What I am saying.
So answer my query.
My lord,
Who has
here
filed
what-
this application for dispensing?
I am not aggrieved by your Lordship. It is a question of record, my lord. If you
Oh, you are on a different issue. Who has filed this application? IA 235 kiye file korchandi?
the review petitioner is not a party to the writ petition, my lord. So therefore, he is seeking leave to prosecute this application.
No, filing ago to leave magichi.
Agya.
Filing of certified copy leave ago magichi. So review petitioner counsel kiye?
Sir, mu.
ଆପଣ ତାହେଲେ ଫାଇଲ କରୁଛନ୍ତି ଏ ପିଟିସନ
ଆଜ୍ଞା
ତାହେଲେ ହବ କି ପରମିଶନ ଦେଇ ହବ the order sought to be reviewed will not come on board
ମାନେ I shall file it.
ସେତିକି ଆନ୍ସର ଦେ ମତେ ବୁଲଉଛନ୍ତି ଆଡ ସାଡେ
ମୁଁ ଆଜ୍ଞା ଅର୍ଡର ଛୁଇଁବାକୁ କହୁଛି
there can't be hearing of this review petition unless there is filing of the order sought to be reviewed.
Lordship may call it some other day.
Leave this matter after filing of the impugned order. Yes. ये modification कितन डांग ये कौन केस?
My lords, order in page 2, opposite party 2 जा रहे 3 है वो.
ए हमर typographical error अछि.
My lords.
All right, देखी दो वाला typographical error. Yes. 33 over. 35 also correct accordingly.
34
correct Mr. Nanda.
Yes, obliged.
Right.
May I please your lordship?
ये
My lord,
35
in item 35, my lord.
हाँ 35 डॉक्का है नहीं अपन आगू कहीं बोल
Sorry, my lord.
Now it is 35. All right. What is this modification?
My lord, one small modification in page number 2 of the order.
कारणदु mask.
My lord, in IA the UAP case number that is that has been mentioned as 213 instead of 231.
That is our mistake or your mistake?
My lord, typographical error, my lord.
Order number?
My lord, order number?
Interim order?
Yes, my lord.
Para 3.
My lord.
So this UAP number stands to be corrected.
My lord.
UAP ta kota koi
My lord,
involve achi?
Annexer 4, my lord. Annexer 4, page 21, my lord.
No, come to your pleading. Come to your pleading, para 24.
My lord.
What is the UAP case number indicated there?
My lord, 200.
What is the UAP case
My lord,
indicated there?
213, my lord.
So what wrong we have committed? Your pleading, you have a wrong pleading. Who is to be held responsible? Or first apply for correction in the pleading. If it is not in terms of Annexure 4, you say.
My lord.
ताले correction आना तो आगे petition रे. तापरे हमें order रे correction करिबा. Dictation is based on your pleading only.
My lord, I beg apology for that, my lord.
So, खाली begging apology ले हबनी. You have to act. कौन करिवे?
My lord, matter. My lord, there is.
बुझंतु ते Mr. घोष बुझेई दियंतु. ये सरला. 36 रे के काउंसिल
For addition item 36.
स्टेट काउंसिल आर थरो कहले आगु को आसु बोली आसिला Petitioner counsel के आसुनांती. Non-appearance for the petitioner. There is also non-appearance of the petitioner counsel on 10/7/23. Matter was adjourned only on the request of the state council on that date. The matter stand dismissed for petitioner not showing interest.
Item 37.
How say 23 matter would have सब delist ହେଇଯିବ.
Well, only that 38 matter, my lord. Item 38, there actually, your lordship has, NCLT proceeding has been stayed. So my humble submission would be that because we had filed the application for challenging the maintenance of the NCLT proceeding. As a result of which, without disposing of that, while that application has been had, my learned friend filed another application and that application is.
No, not correct. Not correct.
Allow him to submit. You will get your opportunity.
So what I humbly submit, my lord, your lordship, because of the stay order, now we are not able to say the.
Tell me, I am not in a position to give into so many order matters.
No, my lord, dear
ମୁଁ
lordship.
ଆଜ୍ଞା 2 ଘଣ୍ଟା ବସିବି ଜମା 2 ଘଣ୍ଟା ବି ବସି ହଉନି.
Next week, next week or week after any date, my lord.
Fourth Friday, third Friday probably occupied.
Third Friday to occupied. Fourth Friday, your lordship.
Fourth Friday को chance नियंतु.
Yes, my lord.
Fourth Friday माने बुझी पारछन तो.
No, fourth Friday to third Friday to sorry gala.
नहीं.
But the 28th is reference. No, 28th is reference. It is 28th is reference. The fourth Friday ta working day.
Fourth Friday ta I will be very much nearing. So I am first.
No. For kaigi nearing kaigi auri passe rahibo. Auri passe rahibo.
ଆଉ ତ ଆଉ ସେତେବେଳେ ଦିନ ଗଣା ହଉଥିବ.
ଦିନ ଗଣା
ମାସ ଗଣା ସରିବାକୁ ଆସିଲାଣି. ତାପରେ
ଦିନ ଗଣା.
May I say 2 sentences, Palad?
ଆଉ କାଇଁ ମୁଁ
Mukhal details my learned friend said because I
had extensively the senior counsels. But there is no time for final hearing. Matter is directed for to be listed in the 4th Friday on so and so.
8th August, 4th August.
କରିଦେବେ date ଦେବେ.
4th August.
Date ଦେବେ.
interim order to continue.
ହେଲା extensively hearing କଲି ଆଉ କଣ.
11th, 10th, 11th I will not be there. So I said the 4th
interim
August.
order to be there.
In 4th, 10th, 11th I will not be there. So 4th August.
What?
37.
ଏଇଟା ହେଲା 38.
The only thing is that your lordship in the earlier order granting stay directed the tribunal to hear the interim applications despite the stay of the concern.
He is not hearing.
When the matter came up yesterday, my lord, as if I have committed a sin to come to your lordship. And those applications have been again deferred without a date being fixed. That is what I wanted to point out to your lordship.
କଣ କରିବା ସେ ତ ବୋଧେ NCLT ତ.
Yes.
ସେ ତ ବସୁନାହାନ୍ତି ଏଠି.
Yes, yes.
VC ରେ available କରୁଛନ୍ତି.
No, physically. Not a regular Monday and Tuesday, my lord, they are sitting. Regular court here. And this NCLT has.
I passed an order and I passed the bulk to the NCLT to look into this situation. They have one man probably attending 4 states or 5 states. That NCLT is attending cases.
Now, Millard, in fact, more members have been appointed.
More members.
They are sitting Monday, Tuesday.
Okay, that's a different issue. What should I do? You may file a contempt. That's a different issue.
Well, I'm not filing contempt. I wanted to point out to your lordship. This is the conduct.
Okay, let him in his wisdom.
Yes.
We will be in our wisdom.
Exactly.
All right, बाकी दीटा केस ये delist कर दियो 39. 40 भी delist होगा. 37 also delisted.
39
Election case नहीं तो इतने किसी.
Entry order 39 रहती.
37 भी delisted.
39 टा entry order.
39 delist कर दो जी. मु आगे ऐसे केस सुनी परिविने बापा.
छोटिया इशू टा पानी पंचायत
ଗୋଟେ କାମ କର ଶୁଣ ଆଉ ଯେ ମିଷ୍ଟର ରାଉତ ଏ ଯୋଉ 37 39 40 ଏ ତ ତିନଟା ଆଉ ରହିଲା 37 39 40 ଏ ତିନଟା କୁ ସେ 5th Friday ଗୋଟେ 6th Friday ଗୋଟେ 7th Friday ଗୋଟେ 5th Friday ଗୋଟେ 6th Friday ଗୋଟେ 7th Friday ଗୋଟେ तापर तो आउ फ्राइडे नथिवो होला
एंट्री मॉडल में कंटिन्यू मानो एंट्री मॉडल टा कंटिन्यू
एंट्री मॉडल wherever there हला to continue
Obliged.